right, have a seat. State having rested what says the defense.
Defense at this time will rest, Your Honor.
All right, so both the state and the defense have rested their cases. As I warned you, now is my opportunity to instruct you on the law. As I also told you, you each have your own set of written instructions that have been just handed out to you, so you can use these. It's not a history test or a civics test. You don't have to remember everything I've said, so you'll have each of these copies to use during the arguments of the lawyers and or during deliberations as you should see fit. I am required by law, though, to read them aloud to you. So those of you who are visual learners are welcome to read along with me. Those of you who would like to be read to, may be read to. Either way, I just ask you to pay attention to the instructions. All right, Jermaine Lavanda Bass, the defendant in this case, has been accused of the crimes of first-degree murder and 2 counts of aggravated child abuse and 1 count of attempted first-degree murder. Here's some definitions that will apply throughout these instructions. A weapon is defined as any object readily capable of inflicting bodily harm if used in the ordinary manner contemplated by its design and construction, or any other object that was used or threatened to be used to inflict bodily harm. A deadly weapon or a dangerous weapon is any object that will likely cause death or great bodily harm if used in the ordinary and usual manner contemplated by its design and construction. An object not designed to inflict bodily harm may nonetheless be a dangerous weapon if it was used in a manner likely to cause death or great bodily harm. A firearm is any weapon which is designed to or may readily be converted to expel a projectile by the action of an explosive. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. Willfully means intentionally and purposely. Killing with premeditation is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the killing. In considering the evidence in this case, you should consider the possibility that although the evidence may not convince you the defendant committed the main crimes of which he is accused, there may be evidence he committed other acts that would constitute what's called a lesser included crime. Therefore, if you decide the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser crimes included in the definition of first-degree murder are second-degree murder, third-degree felony murder, and manslaughter. The lesser crime included in the definition of aggravated child abuse is aggravated battery. The lesser crimes included in the definition of attempted first-degree murder are attempted second-degree murder and attempted manslaughter. Mr. Bass is accused of first-degree murder. First-degree murder includes the lesser crimes of second-degree murder, third-degree felony murder, and manslaughter, all of which are unlawful. However, a killing that was excusable or that was committed by the justifiable use of deadly force is lawful. If you find JAYLA Bass was killed by Jermaine Lavanda Bass, you will then consider the circumstances surrounding the killing and deciding if the killing was first-degree murder or any lesser included that should be offense, or whether the killing was excusable or resulted from justifiable use of deadly force. The killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the killing. The killing of a human being is excusable and therefore lawful under any one of the following 3 circumstances. when the killing is committed by accident and misfortune in doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent, or when the killing occurs by accident and misfortune in the heat of passion upon any sudden and sufficient provocation, or when the killing is committed by accident and misfortune resulting from a sudden combat, if a dangerous weapon is not used and the killing is not done in a cruel or unusual manner. I'll now instruct you on the circumstances that must be proved before Jermaine Bass may be found guilty of first-degree premeditated murder or any lesser included crime. There are two ways a person may commit first-degree murder. One is known as first-degree premeditated murder, and the other is known as first-degree felony murder. To prove the crime of first-degree premeditated murder, the state must prove the following three elements beyond a reasonable doubt. 1, JAYLA Bass is dead. 2, the death was caused by the criminal act of Jermaine Bass. And 3, there was a premeditated killing of JAYLA Bass. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An issue in this case may be whether Jermaine Bass did not act with a premeditated design to kill because he acted in the heat of passion based on adequate provocation. In order to find the defendant did not act with a premeditated intent to kill because he acted in the heat of passion based on adequate provocation, there must have been a sudden event that would have suspended the exercise of judgment in an ordinary reasonable person. And a reasonable person would have lost normal self-control and would have been driven by a blind and unreasoning fury. And there was not a reasonable amount of time for a reasonable person to cool off. And a reasonable person would not have cooled off before committing the act that caused death. And Jermaine Bass was, in fact, so provoked and did not cool off because he committed the act that caused the death of JAYLA Bass. If you have a reasonable doubt about whether the defendant acted with a premeditated design to kill because he acted in the heat of passion based on adequate provocation, you should find him not guilty of the charge of first-degree premeditated murder. To prove the other way you can prove first-degree murder, first-degree felony murder, the state must prove the following three elements beyond a reasonable doubt. 1, JAYLA Bass is dead. 2, while engaged in the commission of an aggravated child abuse on either JAYLA Bass or Jermaine Bass in counts 2 and 3, or any lesser charge on those counts, Jermaine Lavanda Bass caused the death of JAYLA Bass. Or while engaged in the attempt to commit first-degree murder on Jermaine Bass in count 4, or any lesser charge, Jermaine Lavanda Bass caused the death of JAYLA Bass. And 3, Jermaine Bass was the person who actually killed JAYLA Bass. In order to convict the defendant of first-degree felony murder, it is not necessary for the state to prove the defendant had a premeditated design or intent to kill. To prove the lesser included offense of second-degree murder, the state must prove the following three elements beyond a reasonable doubt. 1, JAYLA Bass is dead. 2, the death was caused by the criminal act of Jermaine Bass. And 3, there was an unlawful killing of JAYLA Bass by an act eminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose, and an act is eminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and is done from ill will, hatred, spite, or an evil intent, and is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. An issue in this case is whether Jermaine Bass did not have a depraved mind without regard for human life because he acted in the heat of passion based on adequate provocation. And again, in order to find the defendant did not have a depraved mind without regard for human life because he acted in the heat of passion based on adequate provocation, There must have been a sudden event that would have suspended the exercise of judgment in an ordinary reasonable person, and a reasonable person would have lost normal self-control or would have been driven by a blind and unreasoning fury, and there was not a reasonable amount of time for a reasonable person to cool off, and a reasonable person would not have cooled off before committing the act that caused death, and Jermaine Bass was in fact so provoked and did not cool off before he committed the act that caused the death of JAYLA Bass. If you do have a reasonable doubt about whether the defendant had a depraved mind without regard for human life because he acted in the heat of passion based on adequate provocation, you should find him not guilty of the charge of second-degree murder. To prove the lesser crime of third-degree felony murder, the state must prove the following beyond a reasonable doubt. 1, JAYLA Bass is dead, and 2, her death occurred as a consequence of and while Jermaine Lavanda Bass was engaged in the commission of the felony lesser offense of aggravated battery, and Jermaine Bass is the person who actually killed JAYLA Bass. In order to convict of third-degree felony murder, it is not necessary for the state to prove the defendant had a premeditated design or intent to kill. The lesser offense of aggravated battery for the purpose of this instruction is defined in instruction 8.4 in the following instructions. See also instruction 3.12D, interlocking counts, that we'll get to in a minute as it pertains to this lesser offense. To prove the lesser included offense in count 1 of manslaughter, the state must prove the following 2 elements beyond a reasonable doubt. 1, JAYLA Bass is dead. 2, Jermaine Lavanda Bass intentionally committed an act or acts that caused the death of JAYLA Bass, or the death of JAYLA Bass was caused by the culpable negligence of Jermaine Bass. Every person has a duty to act reasonably toward others. If there's a violation of that duty without any conscious intention to harm, that violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide, as I previously instructed you. In order to convict of manslaughter by act, it is not necessary for the state to prove the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, and which did cause death. I'll now define culpable. Every person has a duty to act reasonably toward others, and a violation of that duty without conscious intention to harm is negligence. But culpable negligence is more than a failure to use ordinary care toward others. In order for negligence to be culpable, it must be gross and flagrant. Culpable negligence is a course of conduct showing reckless disregard of human life or of the safety of persons exposed to its dangerous effects, or such an entire want of care as to raise a presumption of a conscious indifference to consequences, or which shows wantonness or recklessness or a grossly careless disregard for the safety and welfare of the public, or such an indifference to the rights of others as is equivalent to an intentional violation of such rights. The negligent act or omission must have been committed with an utter disregard for the safety of others. Culpable negligence is consciously doing an act or following a course of conduct the defendant must have known or reasonably should have known was likely to cause death or great bodily injury. To prove the crime of aggravated child abuse for counts 2 and 3, the state must prove the following 2 elements beyond a reasonable doubt. 1, Jermaine Bass committed an aggravated battery upon JAYLA Bass in count 2, or Jermaine Bass for count 3. And 2, JAYLA Bass in count 2, or Jermaine Bass in count 3 was under the age of 18 years. In order to prove that an aggravated battery was committed, the state must prove the following 2 elements. The first element is a definition of battery. 1, Jermaine Bass actually and intentionally caused bodily harm to JAYLA Bass in count 2 or Jermaine Bass in count 3. And 2, in doing so, Jermaine Bass intentionally or knowingly caused great bodily harm. It is not a crime for a parent of a child to impose reasonable physical discipline on a child for misbehavior under the circumstances, even though physical injury resulted from the discipline. To prove the lesser included crime of aggravated battery for counts 2 and 3, the state must prove the following two elements beyond a reasonable doubt. And the first element is a definition of battery. 1, Jermaine Bass intentionally caused bodily harm to JAYLA Bass in count 2, or Jermaine Bass in count 3. And 2, Jermaine Bass in committing the battery intentionally or knowingly caused great bodily harm to the victim. For count 4, in order, Jermaine Bass is accused of attempted first-degree murder. Attempted first-degree murder includes the lesser crime of attempted second-degree murder and attempted manslaughter, all of which are forms of attempted homicide and all of which are unlawful. However, an attempted homicide that was excusable or was committed by the justifiable use of deadly force is lawful. If you find there was an attempted homicide of Jermaine Bass by Jermaine Lavanda Bass, you will then consider the circumstances surrounding the attempted homicide in deciding whether it was attempted first-degree murder or attempted second-degree murder or attempted manslaughter, or whether the attempted homicide was excusable or resulted from the justifiable use of deadly force. An attempted homicide is justifiable and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the killing. An attempted homicide is excusable and therefore lawful under any one of the following three circumstances. When the attempted homicide is committed by accident and misfortune in doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent, or when the attempted homicide occurs by accident and misfortune in the heat of passion upon any sudden and sufficient provocation, or when the attempted homicide is committed by accident and misfortune resulting from a sudden combat, if a dangerous weapon is not used and the attempted killing is not done in a cruel or unusual manner. I'll now instruct you on the circumstances that must be proved before Jermaine Lavanda Bass may be found guilty of attempted first-degree murder or attempted second-degree murder or attempted manslaughter by act. To prove the crime of attempted first-degree premeditated murder, the state must prove the following three elements beyond a reasonable doubt. 1, Jermaine Lavanda Bass intended to commit the crime of first-degree premeditated murder. And 2, he committed an overt act toward the commission of first-degree premeditated murder that went beyond mere preparation. And 3, Jermaine Bass failed to complete the first-degree premeditated murder. The line between mere preparation and an overt act is a question of fact for you to decide. Mere preparation consists of devising or arranging the means or measures necessary to commit the crime. An overt act consists of some movement toward committing the crime after mere preparation. An overt act need not be the last possible act toward completing the crime. To prove that a first-degree premeditated murder had taken place, the state would have had to prove the following three elements beyond a reasonable doubt. 1, Jermaine Bass is dead. 2, the death was caused by the criminal act of Jermaine Lavanda Bass. And 3, there was a premeditated killing of Jermaine Bass. To prove the crime of attempted second-degree murder, a lesser included offense of count 4, the state must prove the following three elements beyond a reasonable doubt. 1, Jermaine Lavanda Bass intentionally committed an overt act that could have resulted in the death of Jermaine Bass, but did not result in Jermaine Bass's death. And 2, that act was eminently dangerous to another and demonstrating a depraved mind without regard for human life. And 3, the overt act went beyond mere preparation. An act is eminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and is done from ill will, hatred, spite, or an evil intent, and is of such a nature that the act itself indicates an indifference to human life. The line between mere preparation and overt act, again, is a question of fact for you to decide. Mere preparation consists of devising or arranging the means or measures necessary to commit the crime. An overt act consists of some movement toward committing the crime after mere preparation. An overt act need not be the last possible act toward completing the crime. To convict the defendant of attempted second-degree murder, it is not necessary for the state to prove the defendant had any intent to cause death. To prove the lesser included crime in count 4 of attempted manslaughter by act, the state must prove the following 2 elements beyond a reasonable doubt. Jermaine Lavanda Bass intentionally committed an overt act that could have resulted in the death of Jermaine Bass, but did not result in Jermaine Bass's death. And 2, the overt act went beyond mere preparation. And again, the line between mere preparation and overt act is a question of fact for you to decide, and we've defined that before 2 times already. The defendant cannot be guilty of attempted manslaughter by act by committing a merely negligent act. Again, every person has a duty to act reasonably and use ordinary caution toward others. If there is a violation of that duty without any conscious intention to harm, that violation would be negligence. To convict of attempted manslaughter by act, it is not necessary for the state to prove the defendant had an intent to cause death, only an intent to commit an act that could have caused death and was not justifiable or excusable attempted homicide, as I previously instructed you. If you do find Jermaine Lavanda Bass committed first-degree murder, second-degree murder, third-degree felony murder, or manslaughter, or attempted first-degree murder, attempted second-degree murder, or attempted manslaughter, you will then be asked to determine whether the state has proven beyond a reasonable doubt he personally carried, displayed, used, threatened to use, or attempted to use any weapon or firearm. If you find he committed first-degree murder or second-degree murder, third-degree felony murder, attempted first-degree murder, attempted second-degree murder, or aggravated child abuse, you will also be asked to determine whether the state proved beyond a reasonable doubt that during the commission of that offense, he actually possessed a firearm, whether he discharged that firearm, and whether that discharge caused death or great bodily harm. To actually possess a firearm means the defendant carried a firearm on his person or had a firearm within immediate physical reach with ready access with the intent to use the firearm during the commission of the crime. Mr. Bass has entered a plea of not guilty. This means you must presume or believe he is innocent. This presumption of innocence stays with him as to each material allegation in the charging document through each stage of this trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome his presumption of innocence, the state has the burden of proving the crime with which he is charged was committed and that he is the person who committed that crime. Mr. Bass is not required to present evidence or to prove anything. Wherever the phrase reasonable doubt is used, you must consider the following. A reasonable doubt is not a mere possible doubt or a speculative, imaginary, or a forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of his guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence, you do not have an abiding conviction of his guilt, or if you have a conviction of his guilt, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find him not guilty because that doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you're to look for that proof. A reasonable doubt as to the guilt of Jermaine Bass may arise from the evidence, from conflicts in the evidence, or from a lack of evidence. If you have a reasonable doubt, you should find him not guilty. If you have no reasonable doubt, then you should find him guilty. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are as follows. Did the witness seem to have an opportunity to see and know the things about which the witness testified? Did the witness seem to have an accurate memory? Was the witness honest and straightforward in answering the attorney's questions? Did the witness have some interest in how the case should be decided? Did the witness's testimony agree with other testimony and other evidence in the case? Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in the courtroom? The evidence that a witness may have made a prior statement that is inconsistent with his or her testimony in court should be considered only for the purpose of weighing the credibility of that witness's testimony and should not be considered as evidence or proof of the truth of the prior statement or for any other purpose. Had the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify? Had any pressure or threat been used against the witness that affected the truth of the witness's testimony? Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. The fact that a witness is employed in law enforcement does not mean his or her testimony deserves more or less consideration than that of any other witness. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. Whether the state has met its burden of proof does not depend on the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of evidence presented. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. The Constitution requires the state to prove its accusations against Jermaine Bass. It is not necessary for him to disprove anything, nor is he required to prove his innocence. It is up to the state to prove his guilt by evidence. Mr. Bass has exercised a fundamental right by choosing not to be a witness. You must not view this as an admission of guilt or be influenced in any way by this decision. No juror should ever be concerned that he did or did not testify at trial. Statements claimed to have been made by Jermaine Bass outside of court were testified to in this trial. Any such statement should always be considered with caution and be weighed with great care to make certain it was freely and voluntarily made. Therefore, you must determine from the evidence whether the alleged statement was knowingly, voluntarily, and freely made. In making this determination, you should consider the total circumstances, including but not limited to whether when he made the statement, he had been threatened in order to get him to make it, and whether anyone had promised him anything in order to get him to make it. If you conclude that any out-of-court statement was not freely and voluntarily made, you should disregard it. These are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. First, you must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict would be a miscarriage of justice. There's no reason for failing to follow the law. Everyone is depending upon you to make a wise and legal decision in this case. This case must be decided only on the evidence you've heard from the testimony of the witnesses, have seen in the form of exhibits and evidence, and based on these instructions. This case must not be decided for or against anyone because you feel sorry for anyone or because you are angry at anyone. Remember, the lawyers are not on trial. Your feelings about them should not influence your decision in any way. Your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is then my responsibility to determine a proper sentence if he is indeed found guilty. Whatever verdict you render must be unanimous, which means each juror must agree to the same verdict. In reaching your verdict, do not let bias, sympathy, prejudice, public opinion, or any other sentiment for or against any party influence your decision in any way. Your verdict must be based on the evidence and on the law contained in these instructions. Deciding a verdict is exclusively your responsibility. I cannot participate in that decision in any way. So please disregard anything I may have said or done or any ruling that I've made that make you think I prefer one verdict over another. You may find Mr. Bass guilty as charged in the charging document or guilty of such lesser offense as the evidence may justify or not guilty. If you return a verdict of guilty, it should be for the highest offense on the verdict form for each count, which was proved beyond a reasonable doubt. If you find no offense was proved beyond a reasonable doubt, then of course your verdict must be not guilty. If you do return a verdict of guilty to the charge of first-degree murder, it is not necessary that all of you agree the state proved first-degree premeditated murder, and it is not necessary all of you agree the state proved first-degree felony murder. Instead, what is required is that all of you agree the state proved either first-degree felony murder or first-degree premeditated murder. You will be asked to choose as to each theory of first-degree murder, whether or not you are unanimous as to that theory. A separate crime is charged in each count of this charging document, and although they have been tried together, each crime and the evidence applicable to it must be considered separately and a separate verdict returned as to each. A finding of guilty or not guilty as to one count, but must not necessarily affect your verdict as to any other count charged, except as follows. Legally interlocking counts, and this describes the first-degree felony murder count in count 1 and counts 2, 3, and 4. So first-degree felony murder in count 1 and aggravated child abuse in counts 2 and 3, or attempted first-degree murder or attempted second-degree murder in count 4 are linked in that the aggravated child abuse or the attempted first-degree or attempted second-degree murder is an essential element of first-degree felony murder. So you should consider the evidence applicable to the aggravated child abuse charge and the attempted first degree and attempted second degree murder charge. If you find that the aggravated child abuse charge or the attempted first or second degree murder charge has not been proved beyond a reasonable doubt, then you must find Jermaine Bass not guilty under the theory of first degree felony murder in count 1. But you can still consider whether first degree murder under the theory of premeditation or a lesser offense of second degree murder or of manslaughter have still been proven beyond a reasonable doubt as to count 1, and if so, return a verdict of guilty for that offense. If, on the other hand, you do find aggravated child abuse charge or the attempted first or attempted second degree murder has been proved beyond any reasonable doubt, you can there and must then consider the evidence applicable to the theory of first-degree felony murder. A guilty verdict for aggravated child abuse or for attempted first-degree or attempted second-degree murder does not require a guilty verdict under the theory of first-degree felony murder. You may find him guilty under the theory of first-degree felony murder only if you find all the elements of that crime, including the essential elements of aggravated child abuse or of attempted first degree or second degree murder, were proved beyond a reasonable doubt. Additionally, count 1 lesser offense of third degree felony murder and count 2 and 3 lesser offense of aggravated battery are also linked, and that the aggravated battery in count 2 and 3 are linked to as being an essential element of third degree felony murder in count 1. So you should first consider the evidence applicable to the lesser offense of aggravated battery. If you find the aggravated battery has not been proved beyond a reasonable doubt, then you cannot find him guilty of third degree felony murder. But you may consider whether different lesser offenses of second degree murder or of manslaughter have still been proven beyond a reasonable doubt, and if so, return a guilty verdict for that lesser offense. If, on the other hand, you find that the lesser offense of aggravated battery has been proved beyond a reasonable doubt, you must then consider the evidence applicable to third degree felony murder. A guilty verdict for aggravated battery does not require a guilty verdict for third degree felony murder in count 1. You may find him guilty of third degree felony murder, the lesser offense in count 1, only if you find all the elements of that crime, including the essential elements of aggravated battery, were proved beyond a reasonable doubt. Only one verdict may be returned as to each count, and each of you must agree to the same verdict. The verdict must also be in writing, and for your convenience, we prepared the verdict form for you. And if you'll flip over to page 20, we're going to go over that together just so there are no questions. You'll see on page 20, we, the jury, find as follows as to count 1, murder in the first degree. You check only one letter, A, B, C, D, or E, and answer any questions under the lettered selection. So A, the defendant is guilty of murder in the first degree of JAYLA Bass as charged. And if you select A, you must answer each of these following questions. 1, did the defendant personally carry, display, use, threaten, or attempted to use any weapon or firearm? Yes or no? Did the defendant actually possess a firearm? Yes or no? Did the defendant discharge the firearm? Yes or no? Did the discharge cause the death of the victim? Yes or no? 5, you must fill in a number. Blank of the 12 of us find the killing was premeditated murder. 6, blank of the 12 of us find the killing was felony murder based upon a guilty verdict of aggravated child abuse on counts 2 and 3, or a guilty verdict of any degree of attempted homicide on count 4. And 7, blank of the 12 of us find the killing was premeditated murder and felony murder. Or B, the defendant is guilty of the lesser offense of murder in the second degree, a lesser included offense. If you select B, you must answer those first 4 questions, either yes or no. Or C, the defendant is guilty of felony murder in the third degree, a lesser included offense. If you select C, you have those first 4 questions to again answer yes or no. Or D, the defendant is guilty of manslaughter, a lesser included offense. And if so, you answer that first question, yes or no. Or E, the defendant is not guilty. For counts 2 and 3, those are the same. We, a jury, find as follows as to count 2. That's the aggravated child abuse of JAYLA Bass. A, the defendant is guilty of aggravated child abuse as charged. B, the defendant is guilty of aggravated battery, great bodily harm, a lesser included offense. Or C, the defendant is not guilty. Those same 3 findings under we, the jury, find as follows as to count 3, the aggravated child abuse of Jermaine or JJ Bass. And on the last page, page 22, we, the jury, find as follows as to count 4. That's the attempted murder in the first degree of Jermaine JJ Bass. Again, you answer only one letter, A, B, C, or D. If you select any of those letters, if there are questions under them, you must answer each one yes or no. A, the defendant is guilty of attempted murder in the first degree of Jermaine JJ Bass as charged. You must answer 1, did the defendant personally carry, display, use, threaten, or attempted to use a weapon or firearm? Yes or no. Did the defendant actually possess a firearm? Yes or no. Did the defendant discharge the firearm? Yes or no. Did the discharge cause great bodily harm to the victim? I see I left out the yes or no, so I'll add that before I finalize this verdict form. And then B, attempted murder in the second degree, a lesser included offense, those same 4 questions to answer. C, the defendant is guilty of manslaughter, a lesser included offense, that first question to answer. And or D, the defendant is not guilty. There's also a place for the foreperson to both sign and print his or her name and date the verdict form. So at this time, I'm going to turn it over to the lawyers to give their final arguments to you. I'm just going to remind you of a couple of things. 1, the lawyers are not witnesses, so what they say is not testimonial evidence. So if their recitation of the facts differs from your recollection of the facts, I'm going to ask you to rely on your own memories. That's why you've been chosen as jurors in the first place. Both sides have equal time to address you, but because the state has the burden of proof, they're entitled to go both first and last in their remarks to you. The state prepared to make a final argument.
Yes, sir, but may we approach first real quick?
Sure.
One of them.
Yeah.
Members of the jury, we end right where we began. It was an accidental discharge. I was trying to take the magazine out and it went off. They was both in bed. I was in their room. Those were the statements of the defendant, Jermaine Bass Jr. Mere minutes after he murdered his daughter while she was laying in the top bunk of her bed. Those were his statements as he was holding his son, who was profusely bleeding from a gunshot wound to the side of his head that he caused. It was an accident. I was loading the magazine. I was in their room. Those statements you heard on the body-worn camera of Adam Longman, an HCSO deputy who first responded. I want to draw your attention on that same body-worn camera to the timestamp of 22:46:20, right after he made these statements. The defendant was asked, "What happened upstairs?" He looked straight at the deputies and he said, "Nothing happened upstairs." That man uttered those words, "Nothing happened upstairs," when he knew that his daughter was on that top bunk with a gunshot wound to the middle of her forehead, and she was bleeding out and she was about to die. He said nothing happened upstairs. He didn't beg them to go save her. He didn't beg them to help her. He said nothing happened upstairs. We end right where we began. Right where we began. Where defense counsel in their opening statement to you said, "My client did not shoot JAYLA Bass or JJ." We know that's not true. We know he did it. We know the forensic evidence points to him. And I want you to recall when our blood spatter expert was on the stand. She said to you, "The scene will guide you to collect the evidence that is relevant so that you can piece together what happened." And members of the jury, that's exactly what happened throughout the duration of this trial. The testimony and evidence are pieces that, when laid together, form an arrow that points to the guilt of only one person in this case. The defendant murdered his 5-year-old daughter as she was sleeping, and he tried to murder his 8-year-old son, JJ. Remember this last Friday during jury selection, you were taught that the state has the burden to prove the elements of the crimes charged beyond a reasonable doubt. The judge explained that to you, and in fact, she just read it in this video. It helps to know what the elements are, what we're focusing on as we go through discussing how and why we know the defendant is guilty of each element of each crime charged in this case. We'll go one by one. First degree premeditated murder. To prove the crime of first degree premeditated murder, the state must prove the following 3 elements beyond a reasonable doubt. JAYLA Bass is dead. Number 2, the death was caused by the criminal act of Jermaine Lavanda Bass. And number 3, there was a premeditated killing of JAYLA Bass. He's also charged with 2 counts of aggravated child abuse. There we talk about number 1, Jermaine Lavanda Bass committed aggravated battery upon JAYLA Bass or Jermaine Bass. That's counts 2 and 3. JAYLA Bass or Jermaine Bass were under the age of 18. We know that. Jermaine Lavanda Bass actually and intentionally caused bodily harm to JAYLA Bass or Jermaine Bass, counts 2 and 3. In doing so, Jermaine Lavanda Bass intentionally or knowingly caused great bodily harm. You know that as well. You saw the gunshot wounds. The last count he's charged with is count 4, premeditated murder. Jermaine Lavanda Bass intended to commit the crime of first-degree premeditated murder. Number 2, Jermaine Lavanda Bass committed an overt act toward the commission of first-degree premeditated murder that went beyond mere preparation. Number 3, Jermaine Lavanda Bass failed to complete the first-degree premeditated murder. Let's talk about how and why we know the defendant is the one who pulled the trigger. And let's talk about how and why we know that he did it intentionally. We know that the defendant started out his night by leaving his 5-year-old and his 7-year-old home alone in their beds. We know that's true. 5 and 7, home alone at nighttime. We know that he followed his wife Shirley to her family dinner in the West Shore area at Ruth's Chris restaurant. How do we know that? State's Exhibit 21. We can track his cell phone records. He leaves the children home alone by at least 7:15 p.m. We know that's true because of the video surveillance shows him leaving before that time. We know that Shirley got to dinner and that the defendant arrived in the West Shore area where Ruth's Chris is located. And around 10 o'clock, we know that he's calling Shirley and he's leaving by 10:01. We heard testimony from Shirley's niece, who's kind of more like a cousin or similar in age, China Gadsden. She explained to you what she saw that night. She saw the defendant in his Nissan truck pull in front of Shirley's car that she was driving, stop, get out, walk up to the vehicle, and confront Shirley for going to a family dinner. You know, he immediately got back in his car and went to his house. That's what States 21 shows through his phone records. We know that's true. Just like Anna Cox said, the evidence will reveal to you what happened. Other evidence that reveals this in fact is true, that the defendant followed Shirley to her dinner and confronted her, is the IM crime camera video footage that we see of the defendant's car. We can read between the lines of the evidence we have as to the way the defendant was feeling at the time he arrived back home and went inside where 5-year-old JAYLA Bass was sleeping in the top bunk and 8-year-old Jermaine Bass JJ was laying right next to her. Now again, the scene will reveal itself. You only have to follow it. We know that the children were in the bed together. Laying side by side. In the bed. I'm putting up states 24A because the forensic evidence tells us. We know that JAYLA Bass was laying closest to the wall, her head where this pooling of blood is seen, and that JJ's head was right next to her, either touching the mattress or slightly above. At the point in time that the firearm was pointed at their heads and the trigger was pulled. Remember last Friday when we discussed premeditation, Mr. Terry was talking to you about there's no specific time frame when you're trying to decide whether or not an act was premeditated. It can happen in an instant. Recall that today, Hillsborough County Sheriff's Office firearm expert Jennifer Michaelon took the stand and explained to you what would have to take place in order for that Glock 42 to fire. She explained you first have to take the magazine. You have to load it with bullets. You have to put that filled magazine inside the bottom well of the firearm. You then have to slide the top of the firearm back in order for it to fire. Then, like she explained, when she's firing these firearms regularly during the course of her investigations as a firearm expert, she uses two hands to be able to safely and precisely point and aim within a 6-inch area. Loading the magazine with bullets, putting the magazine inside of the firearm, sliding the top back to make it ready. And then she further explained, not only do you have to point it and aim it, each time you pull the trigger, you have to pull it hard enough to first compress the trigger pull, safety, and then the trigger itself. And she explained to you that because it is not an automatic firearm, that each time you pull the trigger, you have to pull it and let it go, and 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 pull it and let it go. And members of the jury, that evidence is the scene itself, the evidence revealing to you what premeditation is. All of those steps is the scene revealing to you through evidence what premeditation is. Look at the bullet holes. On these precious children's face. Look at that.
Objection, Your Honor, improper.
Sustained.
argument. I
Look.
would ask the jury to be disregarded.
Right. The jury's to disregard the last statement by the prosecutor. Speak facts. Let's talk about the facts.
Look where the bullet holes are located on JAYLA Bass's head. Those are aimed, precise, deliberate bullet holes. That is not an accident. That is not loading the firearm and it going off. Those are aimed, precise, deliberate shots. Shots that require some sort of control over the firearm. shot through her cheek, her temple, and her forehead. Jennifer Michaelon says that shots that are within 6 inches of one another require her to use 2 hands to shoot. This is the shot on the son, JJ's head. Now, recall he's laying right next to his sister in the bed, the top bunk. We don't know what order they were shot, but consider the proximity when deciding how deliberate these shots are. Consider the proximity when deciding how precise they are. That is the evidence revealing to you premeditation, intent, and deliberate shots. Shots that are aimed at the most crucial part of a human being's body. Recall, the scene will reveal to you the evidence necessary for you to come to a conclusion as to what happened. We know from the defendant's wallet that was seized, states 15. Recall that this wallet was taken directly found in a closed drawer within a wallet that was right next to the firearm used to murder JAYLA and Jay, an attempt to murder JJ, and right next to ammunition found. Note on this, height, Jermaine Lavanda Bass, Jr., 5'7". Why is that important? Let's consider the trajectory of the fires shot that killed JAYLA Bass and almost killed JJ. We know that the children were laying next to each other. We know that the blood shown in the pulling of this photo of the top mattress belongs to JAYLA Bass because of the head. Consider the trajectory of the bullets you see. Knowing the bunk bed is topmost portion of the bunk bed is 5 feet 5 inches tall. The defendant is taller than that. We know that damage A is at a downward trajectory, meaning that when the gun was fired, it has to be angled upward, downward to cause that downward trajectory. We know that this shot goes all the way through to the bathroom in a downward trajectory because we saw evidence of that. The scene will reveal the evidence necessary for you to decipher what happened. Whoever was holding the firearm had to have been taller than 5 feet 5 inches tall. We know that there was no stippling found on the wounds of JAYLA Bass, meaning that whoever fired the weapon pointing right at her had to be at least, from the testimony, at least 2 to 3 feet away. If you follow the trajectory of the bullet holes that you see here, take them out 2 to 3 feet, that takes you off the bed. At a height consistent with the defendant holding his hands above the rail and pointing it downward. We know also that the person standing on the outside of this bunk bed, at least 2 to 3 feet away from where the children were laying. We know the trajectory as well because of the impact blood stain pattern. Now, Anna Cox, when she testified, was very educational when she was describing to you what blood stain pattern analysis is. She explained that it's a discipline of forensic science focusing on identifying, documenting, and analyzing blood stains in order to interpret what caused the distribution. Basically, in a layman's terms, she says she looks at the blood stain and tries to decide how it got there. She went on to explain to us different kinds of blood stains and what they mean and how she interprets them. One of them was an impact blood stain, or an impact spattered pattern, which she said a natural object striking the liquid blood. She said she considered things such as physics, the natural laws of gravity, and introduction of a mechanism such as force. So if something were to hit an object bleeding, it would cause a certain pattern, blood pattern stain. Directionality, flow pattern. She said in her expert opinion, based on the DNA evidence that was swabbed from this area, it showed that both JJ and JAYLA's heads were in this corner of the bed at the time in which they were shot. That's an important piece of evidence because, remember, we end where it began. And defense mentioned in their opening statement to you that their client didn't pull the trigger. Well, members of the jury, it's one thing to make a statement like that and then move on. But it requires you to pull the thread, to follow the analysis, to let the scene reveal to you what happened. And you have to follow it until the end. The end is the DNA on the firearm. Now, recall this series of events. The children are shot. They're on the top bunk. When law enforcement arrives, the defendant is holding his son, who's profusely bleeding from a gunshot wound to the head. When he's asked, "Where's the firearm?" he explains to the deputies that it's on top of a dresser, and later explains that it's in the drawer in the master bedroom of the dresser. So let's keep pulling the thread, because what does that mean? It means that after he murdered his daughter JAYLA, and after he shot his son in the temple, that he left them there, walked all the way past 2 bathrooms into the master bedroom, and he opened up that silver drawer. He put the gun and the magazine inside, and he closed that dresser drawer before doing anything else. That's significant. The gun was in a closed dresser drawer. If an accident happened in the room with his children, would not a reasonable parent render aid immediately?
Objection, Your Honor, improper argument.
Overruled.
It's not reasonable to believe that it was an accident. It's not reasonable to believe that after this firearm accidentally discharged 5 times, that someone would then walk past 2 bedrooms into a different room, open a drawer, place the firearm inside of that drawer, and close it before doing anything else. It is not reasonable to believe. We also know the defendant didn't call 911.
Objection, improper argument, Your Honor.
Sustained.
The phone records show that at 10:34, the defendant dialed out to a number belonging to his mother. Anna Cox was right. The scene reveals the evidence necessary for you to come to a conclusion as to what happened. The defendant loaded his firearm with a magazine. He slid it back to load it. He then stood on the outside of that gray bunk bed, put his arm up and over the railing, and fired at his children as they lay sleeping in the top bunk of the bed. The evidence reveals that he shot his daughter JAYLA 3 times, and she died. The evidence reveals that he shot his son JJ in the temple, causing severe injuries that he still suffers from. The DNA puts the firearm in his hands. The trajectory puts the firearm in his hands. And members of the jury, the evidence, when put together, forms an arrow pointing at the guilt of only one person in this case. The defendant, Jermaine Bass, murdered his daughter, JAYLA Bass, who was 5 years old. And he did it with intention, he did it with precision, and he did it with premeditation. The defendant tried to kill his son, JJ. And he did it with intention, he did it with precision, and he did it with premeditation. And the law and the evidence demand that you find him guilty.
Is there reproach?
Yep. Take down the exhibit.
We're missing.
She knows.
right, be seated. Ms. Schlemmer?
Thank you, Judge. May it please the court,
Yes, ma'am.
counsel. I was going to start talking about everything Mr. Terry talked about in opening statement and what he did or didn't show. But I want to first go ahead and respond to Ms. Reeder if I can. First of all, she said, these are things we know. These are things we know are true. She said that Mr. Bass left the children home alone in their beds. So they're in their beds and he leaves. There's no evidence of that. You didn't hear any evidence that they were in their beds when he left. He followed Shirley Bass. We have an hour later with his car supposedly leaving, a Nissan Titan design, but he followed her. There's not one shred of evidence of that. To confront Shirley for going to a family dinner is why he supposedly stopped them along on the way onto 275 at the West Shore exit. You heard not one piece of evidence that he stopped the vehicle. And we're going to talk more about that later, but that it was to confront Shirley for going to the dinner. No, we didn't hear any evidence whatsoever about why or why not Mr. Bass did not go to the dinner. The children were laying down, we know that. Well, then why do we have bullet holes higher up? We don't know that. Miss Reeder actually said, quote, read between the lines. You remember when she just said that in her argument? Read between the lines. Let's forget about evidence. Let's forget about burden of proof. Let's throw it all out the window, folks. Just read between the lines and convict a person of murder. She went through this long, elongated theory, and I think it was done multiple times, that Mr. Bass got the gun. He put bullets in it. He put the magazine in. He racked it. He took it into the kid's room. What evidence did you hear about any of that? You heard not one piece of evidence of where that gun was prior to the shooting of the children. You heard nothing. We do not know. You don't read between the lines in a case such as this or in any case. There is absolutely no evidence that the state has presented where that gun was prior to the shooting, who loaded it, wasn't that, we know nothing. And they have to have evidence. Ms. Michelin told you that they didn't do a trigger pull. They could have done a trigger pull on that gun and given you a poundage of how much force. I think Ms. Bradley had asked her, it's about just 5 pounds. But what did she tell Ms. Bradley? The trigger pull on that gun is as easy as popping off a soda cap. Popping off a soda cap is enough force to pull the trigger on that gun. So the state wants you to believe that Mr. Bass did all these things. Well, because that's their theory, that's what they want you to believe. He got the gun, he racked it, he put the magazine in, he pulled the slide back, all of that. But you gotta look at the evidence, not their theory. Remember, the judge will tell you the evidence is where you look, the exhibits and the testimony. Not one piece of evidence about that. Ms. Reeder talked about the wallet being found next to ammo. I guess to presume that that's an important factor. Not any ammo that could have been used in this case for certain, because there's not one thing found in the master bedroom that had anything to do with a .380. Detective Holberman and Corporal Gaveau both told you that. How do I know? How do I know that Mr. Bass's driver's license height is even correct? Not one shred of evidence presented as to that. They want you to read between the lines and assume. Whoever is holding the firearm had to be taller than 5'5". We know that, said Ms. Reeder. Where did you hear that evidence? What witness said that? Nobody did. Theory, not evidence. And again, going through how he then afterwards goes into the master bedroom, does everything, puts the gun up, and closes the drawer, she said. Right? Evidence. That drawer's open, so that's not true. This is the way HCSO found it. That drawer is open. So what Ms. Reeder said there is not supported by the evidence. There is not one shred of evidence to support their theory and everything Ms. Reeder had just said to you. You've got to look at the evidence. You've got to look for the evidence. So let me go back then. In opening statement, Mr. Terry told you the following. Mr. Bass doesn't call 911. You will find out who he calls. Well, Shirley calls 911, or Mr. Evans actually calls 911 and gives the phone to Shirley. Shirley's calling 911. Why is there a reason for the spouse to call 911? You heard evidence, not theory, but evidence, that DeQuan and then Shirley, the call is made at 22:33, the 911 call. Mr. Bass does not call his mother until after that. Evidence, that's what you heard. Mr. Bass isn't calling Domino's to order a pizza. He's not calling for takeout. While Miss Bass is on the phone with 911, that is when Mr. Bass calls his mom to tell her what happened to her grandchildren. So we know from the timing that that call to the mother is definitely after the 22:33 911. Look at the phone records. It is 22:34, right after. We also know that it's a very quick call. 5 seconds may not have even been answered by his mom. All right, number 2, Mr. Terry says, Mr. Bass tells the police exactly where to find that gun. Presuming, I guess, he knows specifically because he's the one that pulled the trigger. Well, no, not quite. And Ms. Reeder even pointed this out in their argument, is he's telling them that it's on the dresser. It's not until later that he says, look in or on the dresser. Ms. Reeder even told you that. And we have no evidence of where that gun was prior to the shooting. None at all. Ms. Reeder made a comment about Mr. Bass making the statements to the deputies that first responded. The statements are made mere minutes after the shooting. Well, the 911 calls at 22:33. The statements, she said it herself in her closing, 22:46. That's 13 minutes. Marital discord. Mr. Terry said, oh, there's marital discord, and maybe that's why he did this tragic, horrible act. What evidence did you hear of marital discord? Absolutely none. Again, you have to look to the evidence, not their theory. Because they have the burden of proof to prove beyond and to the exclusion of a reasonable doubt. You did not hear about any marital discord from China Gadsden, nor did you hear about any marital discord from Ms. Romeo. Mr. Terry said, you will never know why. He's correct, absolutely, when he says they do not have to prove motive. You will never know why. Well, we don't. And the problem is, there are so many unanswered questions over this tragic, terrible event that took place on August 29th of 2022. Many unresolved questions, mistakes made in this case by many different people. Too many unresolved or answered questions. Reasonable doubt. Mr. Bass didn't go to Ruth Chris because he was supposed to stay home to take care of the children. Mr. Terry said that. Where'd you hear that? Did you hear that evidence? Stayed home because he had to take care of the children. No evidence. Nada. There was no evidence presented of why he did not go to Ruth Chris that evening. Something is not right in that house, okay? What evidence did you hear that there were any problems in the house? Nada. Mr. Terrigan, Mr. Bass was angry and aggressive on West Shore and 275 when he came upon Miss Bass and Miss Gadsden. Well, no, that's not what we heard. We specifically did not hear from China Gadsden say he was angry. You didn't hear that. Nada. She claims he comes upon them and all he says, were you drinking? You know, is that why she's driving? That's it. They're not arguing. They're not beefing. He's not yelling. Shirley wasn't fazed by it, China said. And that's it. And, folks, that's if you believe this story. Okay, we have China Gadsden, the one, she is related to Shirley. And one of the most critical things is, if this was a big deal, and this somehow is their great motive, theory, that's what they want you to believe to convict somebody of first-degree murder, why is it not talked about earlier? China Gadsden never says a word until over 14 months later that this allegedly took place. Corporal DeVoe even told you there would be times he would call China. She'd hang up on him. I don't want to talk to you. I'm not going to talk to you. All of the behavior of everybody in this case, Mr. Bass, Mrs. Bass, the witnesses, you can consider. And their behavior and everything that got done that evening. And China Gadsden never at any time said Shirley was upset. Now, I just want to make this comment. Do you honestly believe in Florida that they're sitting there stopped in the middle of the road and they're just sitting there and Mr. Bass goes out and he says, are you drinking? Were you drinking? Because is that why she's driving? That's it, right? That there's a ton of cars backed up and that one person is honking. This is Florida. Not one person is honking or blaring, saying, you guys need to go. That's what China told you. Miss Bradley asked her, well, weren't the cars like honking if this story is true? Oh, no, it's fine. They were just waiting. Come on. It's just unbelievable. This was an act to kill, Mr. Terry said. Well, where is the evidence? Where is the evidence of premeditation, the intent to kill, reflection, enough time to reflect on that? Where is the evidence that the premeditation and intent to kill was in his mind before the act? We have no problems talked about, no issues, no evidence, none. No threats, nothing. Shirley was frantic on the 911 call, of course. She's frantic, she's upset. But you gotta look at her overall behavior in this case. You can look at all of that, and you should look at all of that. The 911 operator is constantly asking her, who did this? Who did this? Is the shooter still there? This is a mother. Supposedly, Mr. Bass has just shot and killed her daughter and shot her son. She refuses to answer that question. Never answers that question. At one point, Miss Bradley talked about this in her opening. She specifically says, no, I don't need police, I need an ambulance. And of course, you'll have the call to listen to. We also had absolutely no clue who she's yelling at on that call. We know for a fact from the call, she's definitely yelling at the 911 operator for not getting there fast enough to bring the ambulance. We know, and she says it, how upset she is with the operator. Look at when the call comes back. She even says, I got the same person. I got you again. So we know she's upset with the operator. And listen to that call. Did you catch the comment about what Shirley said? Her son was supposed to be sleeping. But then he ran. What? Okay. Well, that just further shows me we do not know what happened in that house at the time of the shooting or what happened before. Listen to that call. You're going to hear her say that. And then he ran. Supposedly, as Miss Reader says, the children are shot in their beds. That makes absolutely no sense. Now, we know from Mr. Evans, Daquan Evans, that there was about 5 to 10 minutes span of time. That's what he testified to. Evidence. 5 to 10 minutes from the time he heard the shots to Shirley coming to his door, because she doesn't know the address where she lives. She doesn't have her phone. 5 to 10 minutes between the shots and Shirley coming to his door. What is going on in that 5 to 10 minutes? Ask yourself that. What is going on with Shirley, Mr. Bass, in those 5 to 10 minutes? We also know there's 2 parts of the call. There was no evidence presented by the states to show the time difference. In other words, was it 5 minutes between the calls? Was it 5 seconds? We don't know because they didn't present that. And we certainly know, continuing in that second call, Shirley is still not happy with that operator. Take that in consideration as well as the first deputies at the scene. They're all equipped with body cam. Rahman, Rainey, White, and Jones. The big picture is what you can look at. Deputy Jones, I asked her repeatedly, who shot her son? He's asking a mother whose son has been shot in the head. Who shot your son? Is the person with the gun in the area, please? Never. His testimony, evidence. Shirley never answered him, never answered his questions. Deputy White, evidence. The woman was yelling at the officers. We were just trying to help. Deputy White, Shirley was uncooperative in providing any answers. Evidence. Now, the state, I anticipate Mr. Terry's going to get an opportunity to come up and talk to you when I'm done. Please keep in mind what he says and think what I might say in rebuttal to that, and keep in mind he has the burden of proof. But I anticipate, since this is my only time to talk to you, he's going to say, well, she was traumatized, right? She's traumatized. So you got to look at that whole big picture about her uncooperativeness, and we'll talk more about that. But it doesn't explain this case and not answering simple questions posed to her by a 911 operator or the deputies. Who shot your son? My husband. Never, nada, never says that. Deputy Jones, the lady wasn't very helpful. That's it. Not helpful at all. Now, Mr. Bass, another comment from opening statement by Mr. Terry. Mr. Bass never tells the police his daughter is upstairs. Not true. Evidence. You heard from Deputy White. Body cams, you got beeping going on, they're difficult to hear. Deputy White said that Mr. Bass did say something about a little girl, and he documented it in his report. It wasn't just off his body cam. He told you that. I heard that. What you kind of hear on the body cam is something like, anyone upstairs? No. Then you can hear something. Watch those body cams again. Something is said right after that. And I believe that Deputy Rainey's body cam may be one of the best to pick it all up. But listen for the word daughter. Then, is anyone else in the house? No. But I make that up. Deputy White took that witness stand under oath and said he did say something about his little girl. But Mr. Bass is not allowed to be traumatized. Well, Shirley Bass is. You can't have your cake and eat it too. Now, Deputy Jones even told you, well, I didn't hear that. I didn't document it in my reports, but he said no. But I was walking behind Deputy White. And I just walked quickly past Mr. Bass. And he specifically told you he might have heard something, Deputy White, that Deputy Jones did not. Evidence that was his testimony, because Deputy Jones was behind Deputy White. Evidence, he told you that. So I ask that you watch those body cams again. I'm sure Mr. Terry will say the same thing. Now, let's continue on concerning Shirley Bass. Her daughter was killed in a tragic event. Her son was shot in the head. But she desires to be uncooperative with Detective Gabot. He asked for her phone. Remember, her phone was in the crime scene. Some member of HCSO went into the crime scene, took her phone out, and gives it to her. So she has her phone back. Mr. Bass's phone, able to be downloaded, is on the couch. You can see it, right? He's asking, I want to download the phone. No, never does she give her phone to him to do a simple download. And guess what, folks? You saw phone evidence, right? Now, I believe it was Corporal Gabot said there wasn't anything on Mr. Bass's actual download, but that's why they look at it. That's why they do a cell write. Because it does reveal evidence, and it is important. She was hard to reach, he told you. This is a woman whose daughter was killed and son was shot in the head. Mary Lee House, you heard about Mary Lee House. That's kid-friendly. There's just the interviewer that works at Mary Lee House who's trained to speak to children in a kid-friendly environment. They have to do, and they want to do an interview of JJ based on what happened, what he saw, what he did. On 9/7 of 2022 in the AM, Shirley absolutely refused to let her son be interviewed. Now, the state's going to say, oh, just Corporal Gabot said he was just out of the hospital. Well, then say that. Can we wait a little bit? No. She lies to Corporal Gabot. You heard that. And said, well, I got here earlier and I waited a long time. Remember he told you that? What else did he tell you? That's not true. Because I was here early and she was not here. So we know that's false. And Corporal Gabot, what other interesting thing did you hear about that first attempt to interview JJ? Oh, I never even saw the son. He doesn't know if she even brought him that day. So he says, okay. So we set it for the afternoon, same day, September 7th of 2022, for the PM. Now at this point, JJ's uncooperative. We didn't hear testimony that he was in pain or he was upset. Look what had just happened to his sister. We don't hear that. What do we hear? And I hate to even talk about JJ like this. I'm just going to tell you the evidence, please. Corporal Gabot tells you the interview did not take place, that second attempt, because he was disrespectful, had bad behavior, and was actually physically attacking Shirley. Then we have another attempt. Well, let's try to do it on 9/12 of 22. It's now reset for the third time. That interview didn't take place. We know at that point, Detective Bernal and Detective Latou have to go get an investigative subpoena. Corporal Gabot told you all about that. It isn't an invitation, Corporal told you. It was served on her on September 23rd of 2022. So finally, I think this is the fourth attempt at this point. You know, not Shirley, just give me some time. No, excuses, excuses, excuses. Finally now, only over a threat of being arrested if she doesn't bring JJ in, does the interview take place. This behavior is not consistent with a woman whose husband just in cold blood, premeditated, shot his daughter, Shirley's daughter, 3 times and shot her son in the head. It just makes absolutely no sense. Corporal Gabot told you she was uncooperative with the investigation. Some things she was cooperative with, he told you. He didn't quite tell you what those things were, but she was uncooperative. Just the same as you've heard from every single deputy that took that stand, the first responders. He also said, quote, Shirley was uncooperative with all attempts to have her son interviewed. What is going on here? What exactly happened in that home? What is going on? Do you really know, beyond and to the exclusion of all reasonable doubt, what happened in that apartment, that townhouse, for that gun to be shot and the children to be injured? Mr. Terry, in opening, Shirley was very frantic. He also seems to imply in his opening, but Mr. Bass wasn't, right? Shirley is frantic on the body cams. We see her. But nobody has met Shirley before and doesn't know how she acts. Nobody has met Mr. Bass before and see how he acts. Not Mr. Evans, not the deputies. We talked in Board Dyer, if you remember this. Do people act differently to trauma? You guys agreed, yes, you can. No two people are alike. You can be frantic, or you can be like a blank slate and in shock. It sounds like Mr. Bass and Shirley as well. So people react differently to traumatic events. And certainly being, quote, blank and quiet, the words of Mr. Evans to describe Shirley Bass describes Mr. Bass. In addition, you can consider what everyone else told you from the Sheriff's Department concerning Mr. Bass. Unlike Shirley Bass, he was cooperative with the investigation in all stages. Now, we also know that we hear Mr. Bass tells the deputies, come in, come in. You can literally see, watch the body cam, he's all sweaty. You can see the shine because he sweat from trauma. Just help my child, please. I believe Ms. Reader just said in her closing that he never asks for help or to help his children. Absolutely false. Just help my child, please, please get the paramedics. Again, evidence from the body cams. Mr. Terry, in his opening, Mr. Bass said it was an accident. This was no accident. Did y'all notice that when Mr. Bass is first asked by the deputies how this happened, what does he say? He says accidental discharge. That's what he says to me first. He doesn't say, I did it, I shot it. He says accidental discharge. It's a period of time. Deputy Rainey steps outside. He notifies that they have found JAYLA and that the house is clear. Comes back in the house. They're frantically taking care of the children. Fire rescue is coming in. Later, when Deputy Rainey is asking more specific questions, then, and only then, does Mr. Bass says, it was me, I was cleaning the gun. Common sense dictates no one's going to be cleaning a gun in a kid's room. What is going on in that house? What happened in that house that tragic evening? We don't know. You didn't see any cleaning supplies out, did you? I submit to you, he was not in the kid's room cleaning the gun. He was protecting someone else. It just makes absolutely no sense. And evidence that you have is that we do know that there was a substantial period of time, 5 to 10 minutes between the shots and Shirley coming to ask to use Mr. Evans' phone. Why she's even doing that, I don't know, because her phone is in the townhouse where it's retrieved by one of the members and given back to her. And we know there's a gap in the calls. What did Mr. and Mrs. Bass discuss in that time period? Is Mr. Bass protecting someone? We don't know. Questions unanswered. That is when you have not proved your case beyond and to the exclusion of a reasonable doubt. So based on some of those things that we have just talked about, Do you believe that this case has been proved beyond and to the exclusion of all reasonable doubt? You have to look to the state for those answers. You have come away, or we submit you kind of have come away with more questions than anything else. Please keep in mind as well, we do not have to provide you, the law says, and try to explain who pulled that trigger, what happened, how the shooting took place. Remember, you need to look to the state for the evidence. We do not have to give you scenarios, explain what happened, discuss what happened. You have to say, did the state prove this beyond and to the exclusion of a reasonable doubt? So I want to talk about the law just a little bit, because we talked extensively in voir dire. Remember the presumption of innocence. You go back to that jury room. Keep in mind that it must be completely removed. We know we have a person and they're clothed in that presumption. That's our law in this country. It must be removed completely in order for you to consider a guilty verdict, in order to convict. Now, please don't be misled. There are no percentages in the jury instructions, but it's a way to kind of explain it to you. The presumption of innocence must be taken off of Mr. Bass 100%, right? Because that's the only way they can carry their burden and prove their case. If it's removed 50%, there's reasonable doubt. If it's removed 75%, there's reasonable doubt. If the state has only reviewed it,
Judge, I'm
removed
gonna
it
object to this
95%.
line of argument.
Sustained. There's no specific percentage as relates to reasonable doubt. It's an abiding conviction of guilt.
And as I told you, please don't be misled. Now, what is reasonable doubt? The judge gave you the definition of it. She talked in voir dire about it and told you it's basically a doubt you can attach a reason to. It comes from the evidence, a conflict, or lack of evidence. Now, like Ms. Bradley told you in opening, this was tragic. Members of the jury had to see the photographs, listen to the evidence. Tragic. That was a tragedy, what happened that evening to those children. But you cannot let sympathy affect your verdict. I know it's hard. You cannot. The judge instructed you of that. You cannot let sympathy or bias affect your verdict. You must follow the law. And the question you need to answer is, has the state removed that presumption of innocence completely? And if they have not, the verdict has to be not guilty. That's our law. Ms. Reeder and Mr. Terry have done their jobs. Because they've done their jobs and presented evidence does not mean they are able, through the evidence, to remove that presumption. That's going to be that's up to you guys. As the judge told you in the jury instructions, I believe you have the copies, you get to go back there. The presumption of innocence must be overcome by the evidence beyond and to the exclusion of a reasonable doubt. And also remember, the abiding conviction of guilt and conviction of guilt. Judge gave you the instruction, we talked about it in voir dire, you have the instruction. That part of the instruction starts off talking what reasonable doubt, which is a concept sometimes hard to define, is what we talked in voir dire about. It's not a possible or speculative doubt. I told you that. However, if after carefully, or on the other hand, I believe it says, on the other hand, after carefully considering and weighing the evidence, there is not an abiding conviction of guilt. Or if you have a conviction of guilt, but it is not stable, it wavers and vacillates. That means and shows you the charge has not been proven beyond and to the exclusion of all reasonable doubt, and the law requires, it's tough in a case like this, but the law requires a not guilty verdict. That was what we were talking about. Mr. Terry, I stole from him in voir dire when he used the waver and vacillating to talk about premeditation. Same thing. You go into your closet that morning and you're trying to decide what to wear, and you can't quite decide. It's waver and vacillating, going back and forth. And if you can even have a conviction of guilt. No abiding conviction of guilt or conviction of guilt, but not waivers of assets. It has to be by law, not guilty. So if you go back in the jury room and you're thinking to yourself, well, he's possibly guilty, he may be guilty, he could very well be guilty, he's probably guilty, then you're having a reasonable doubt. And please keep in mind that we do not have to have proved Mr. Bass's innocence, rebutted anything that was said. I think we showed you quite a bit, and a lot of the problems and errors in this case. But at this point now, we're at Wednesday, there's just too many questions in this case to overcome that presumption of innocence. And those questions have not been answered. You cannot look at Ms. Reeder or Mr. Terry's theory. Evidence, evidence, evidence. As I said in jury selection, what does not guilty mean in our country? Well, that's exactly what it means. Not guilty means the state has not proved their case beyond to the exclusion of a reasonable doubt. So with our laws, do you have to sit there and go, I'm totally convinced he didn't pull the trigger? That's when I say not guilty. No. Our law says if the state has not proven their case beyond to the exclusion of a reasonable doubt and remove that presumption of innocence through evidence, not theory, then you have to by law return the not guilty verdict. The state has to prove who did it and has to prove Mr. Bass acted with premeditation or felony murder. You have the instructions with you. So I want to just talk a little bit then about the crime scene, the autopsy, and they all present holes in the state's case. Let me start off with Dr. Riley. Mr. Terry said to Dr. Riley in his direct examination, and Dr. Riley agreed, were you there the entire time for the autopsy? Yes, I was there. I wrote the quote. I was there with Dr. McGowan the entire time. Well, no, that's false. We know that's not true. We presented that to you. I said, whoa, hold up. Again, we didn't have to do this. I go up and I'm like, whoa, wait a minute. You weren't, were you? You were in and out. You had other autopsies going on while this autopsy was taking place. That is correct. And I had other things to do as well. But yet he told you, oh yeah, I was there with him the entire time on direct. Dr. McGowan did the autopsy. Dr. McGowan did the report. Then we have the interesting issue of Dr. Riley. And I'll explain in a minute why all this is important, and then we'll talk about the other mistakes in this case. Dr. Riley testified under oath in his deposition that gunshot wounds A and B on JAYLA, Ms. JAYLA Bass, were slightly downward. He took an oath, he testified they were slightly downward. That's what's written in an official document, the official autopsy report. So it's in the autopsy report, he testifies under oath. That's wrong. What else could be wrong? For this autopsy, he was doing other things, doing other autopsies. It's important. So it's wrong at least twice. You heard that. And it's funny because my last thing to him was, but didn't I even ask you in your deposition when you were under oath, did you find any errors in that report? And you said no, and I think his exact words were, this is something I would say. Yeah. So Mr. Terry gets back up on redirect, but does that have anything to do with the cause and manner of death? And Dr. Riley says, no, I have not changed my cause and manner of death. From the autopsy he did not conduct. Why does it matter? What the autopsy showed matters. What the autopsy didn't show matters. Stippling matters. Direction matters. Where a person is shooting a gun that he can testify or not testify to matters. His findings matter. What else is wrong? What else is incomplete? And this is the type of evidence that Mr. Terry and Ms. Reeder would claim they have carried their burden of proof with. Dr. Riley, honest with you on these points. I cannot tell you who pulled the trigger. I cannot even tell you where the shooter was. Remember, Miss Reader? Oh, the shooter was standing right next to the bed. It's Mr. Bass, and he puts his arm over and reaches and shoots. You heard no evidence of that. You heard to the contrary. Dr. Riley says, I cannot tell you where the shooter was. Who else said that? Anna Cox. I can't tell you where the shooter was. I can't tell you any of that. So what is all this? Theory, not evidence. Now, this is very important when it comes to the stippling, because they're talking about there's no stippling on JAYLA's wounds. Dr. Riley said there's no evidence based on what he sees for close range firing. And he told you that is the only thing that indeterminate range means. What else did he tell you, though? There are many variables and numerous factors that can affect the leaving of stippling. Number one, the type of firearm itself, which, by the way, he wasn't even aware of what type of firearm. Number two, the type of the firearm. So the firearm itself and how it works, and then the type, 38, 9, 57. And it depends on how much gunpowder is in the cartridge of the ammo. So these are all factors that he is telling you evidence affects whether you can see stippling or not. No further testing was done by HCSO to fire the gun and see that gun with that specific ammo where you see stippling or if you see stippling. Now, State wants to also talk about distance. Ms. Reader, I think, said something about Mr. Bass puts the gun right up to them or to their heads, something like that. I specifically asked him, are you able to give us an opinion on how far, in this case, the end of the muzzle, so where obviously you guys know about firearms, where it ejects, was to JAYLA's gunshot wounds. That's your distance. In this case, I cannot tell you that. I had no opinion. Remember that? Evidence. When he's talking about, well, generally you'll see stippling under 3 feet or under 2 feet. Generally. Typically. But I need the firearm. I need the ammo. And he, of course, he doesn't do that kind of stuff. HCSO would be responsible for actually testing that firearm. So, and of course, we have no evidence concerning little JJ in that field. So, keep all of that with a grain of salt and remember what Dr. Riley really said. Shannon Bader and Clay Hoagland, what other errors did we have? Why is it important? Guarantee you, Mr. Terry's going to get up here. And anything I said about what about this, what about this, what about this, you have questions not answered. It's going to say, that doesn't matter. I have to prove that JAYLA is dead, and we've agreed to that. Clearly, it was JAYLA Bass. He's got to prove the elements of the crime. But you look at the whole big picture. How was the evidence collected from the scene? They relied very heavily on Ms. Cox's opinion. I'll get to her in just a minute. But here's something pretty critical. Shannon Bader made a mistake. She puts in her report, she puts on property receipts, and she says in her deposition under oath that projectile was taken from the bottom bunk mattress. So what would that make that look like then, right? It makes it almost look like she's telling you, or the evidence at the time, is that one of the shots or two of the shots, what have you, are on the bottom bunk as well. So that's her mistake and what her mistake led to. That's important. That's important. Because we know that's not the case. But yet when you look at this, wait, what is their scene saying? I think Ms. Reader said it 5 or 6 times. What is the scene telling you? What is the scene telling you? The sheriff's department collects a metal clip, evidence marker 1, for like gauze if a person has a wrapped up arm or something like that, a little metal clip. And they collect or they document it. I wasn't sure if they collected it or just documented a piece of gauze on the top of the staircase. That was important enough to do. Well, what wasn't important enough? Let's go over that. Gunshot residue testing. You have the kits, you can do it, and then send it off for testing, which they told you they can do, but they did not do. Now, I believe Miss Reader or Mr. Terry was talking to, I think, Corporal Gabot today. And he says, well, you wouldn't bother to do that on Mr. Bass because he admitted he shot the firearm. And he said, well, yeah, that's why I didn't bother with him. What about everybody else? Everybody else was at the scene. The medical examiner's office had some sort of question concerning, you heard about this, whether they should swab the poor little JAYLA's hands. Because her hands are bagged to protect it. What did Clay Holdeman say when he spoke to somebody at medical exam? Nah, we don't need any special processing. We're not worried about that. So there's a lot more to that picture. There's only one swab done on that entire top mattress, and that's the swab over towards the pillow that came back as little JJ. One swab is done on the entire, and I'm only speaking of top of the mattress, to determine or try to determine possible positions of the children. I asked Detective Holdeman, well, why wouldn't you do, look at all that blood. Why wouldn't you do some other swabs? I'm not talking about the frame, I'm not talking about the wall. I'm not talking about the staircase, where we know we have little JJ's blood. Why would you not send out some more swabs? You have blood on the east end, in the middle, and on the west end. We can tell from the evidence JAYLA is clearly somewhere near the pillow, yes. But I asked him, why did you only send swabs from the magazine, the trigger grip, the slide, and the one swab that Anna Cox wanted done on the comforter? Well, it would take too long. It takes a good 12 months to process things. I wouldn't have had it ready for trial. So that's why I didn't bother. That was his answer. I don't make this stuff up. That was his answer. What did I talk with Ms. Weinstein? I hope it is. I'm not mispronouncing that. We talked about her reports, right? 3 months. And that's 3 months from the evidence coming into FDLE, being in their evidence vault, eventually making its way to her area, being processed, filing a report, and authoring a written report. 3 months on pretty much everything she did. There was plenty of time to process this scene better, so maybe you would have your questions answered. This was mid-2022. It is 2.5 years later. The only swabs that are done on the frame, not where B is, where they saw a substance. We saw red substance on the frame all down on the east end. I'll get to the comforter in this Cox in a minute. All swabbing over there. I'm not talking about swabbing on the west end, where clearly we have the coagulation and where little JAYLA is shot. We have it on the west end. We have it in the middle. We have it on the east end. We have it on the walls and the frame. Look at that east side. Not one swab done. That would help us with movement. That would help us know. Now, Anna Cox, who does 70% of her work for prosecutor's office and police agency, she wants you to believe that every bit of blood on that comforter, because we only have the O tested, and then we have the impact spatter up on top, the one area of impact spatter, which has JAYLA's DNA and a limited inclusion for little JJ. You have the DNA results. But she's telling you that every single bit of blood in the middle of that mattress and going all the way to the east side, that's all from the comforter. You saw multiple pictures of that comforter. It's in different spots, even in the picture. Walls, frame, and mattress. We know it's moved by first responders. You see in the body cam, it's kind of next to her legs. There's a picture with the comforter. You'll have the pictures back there, laying in the middle of the bed. Remember that? And I almost said, well, there's a U-shaped here. It was kind of spread out. And there's a whole bitch of blood right here that's not even touching this comforter. Oh, look at the whole sequence of photos, Miss Cox says. You have the photos. Then we see a photograph of it way over on the east wall. That's the preservation of their scene. Multiple locations of one piece of evidence. And guess what? Detective Holdeman had absolutely no idea that first responders had moved that comforter, moving evidence in the crime scene, until I told him. I told him in deposition. It's in the body cams. He didn't know that. And he's a scene detective. We had to tell the crime scene detective in a homicide case where children are shot these things. That's a problem. That's a problem. We know that they had the issue with the label of the B. They thought B went through the wall and was B1 and B2. That's a simple mistake. They moved the bunk bed away and they could tell that B is not related to B1 and B2. Right? Yet Anna Cox sounded very sure of herself. In fact, I think this reader used the term, she taught you. If you'll happen to notice as well, she appeared to be the only witness in this case who continued talking and after the question had been answered. Everybody else answered the question as they should. But here's what's critical. JAYLA's head and Jermaine's head and possibly his hand was at the northwest corner. Why?
Hey, I'm sorry to interfere. Do you need me to end this for you?
Because of that one area P, the impact static. That's why she said this. He said, well, all gunshot wounds aren't going to leave impact spatter. Oh, yes, they will. Generally, in my, you're going to leave your common sense at the door. You don't have to leave it at the door. She was even aware that P, the impact spatter spot, was a limited, little Jermaine was included in a limited capacity. And you have the stipulation on that. So then I said to her, well, look, all right, she's processing a scene which had been not done 100% correctly by HCSO. Some mistakes are made. You can't give us the exact position of JAYLA and little JJ's head, correct? Oh, yes, I can. It was in the northwest corner. I'm like, okay. And she said it again and again. I said, hold up. That's not what you told me in deposition under oath just December of last year. That's not what she said. I had to show her her own words. She said, proximity of the northwest corner, I cannot give you the exact position, just somewhere in the proximity of the northwest corner. So she said in December, under oath, she comes in, teaches you, shows you her PowerPoint. Oh no, yeah, no, their heads are definitely there. You can consider that. And of course, none of this that we're even talking about so far about the crime scene and the autopsy is telling you to pull the trigger. So you can consider all of that. Talking about Ms. Cox, don't you think if the sheriff's department had seen biological material, that somebody would have mentioned it, somebody would have put it in a report, somebody would have had that tested? She looks at some pictures, photos only, and says, oh, that's biological material there. Well, do we know? Was there DNA done? Do we have any idea? Just a picture. Well, no, that's what it looks like to me in my experience. It was also interesting because she said something about drips of blood by the couch. I guess away from the couch, because we know Mr. Bass is sitting there cradling his son. The officers all told you there's blood coming down. Said something about some drops. That's not documented by Bader or Holberman. The green scale marker on the ground there shows what you decide. It looks like a little footprint. We know that's the area in which Mr. Bass brings his son down and sits down on the couch. You didn't hear about little droplets on the floor from the sheriff's department. And you know what? I guess even if they were there, like she said, that's understandable through the evidence. We know for a fact Mr. Bass brought his child down. Just like the blood that's down the staircase and all that, all understandable, all explainable, and she told you that. Why wasn't anything done at all with the swabs taken for the gunshot residue? The comforter, wherever it is, you know, it's more towards the left, could have been right under where that gun was, where the gun's being fired. In fact, I think Miss Reader says kind of that it's lifting over, going right on top of it, to show us positions. But why wasn't anything done then at all? Well, we don't know. They took swabs for gunshot residue. They did infrared light, did nothing with it at all. I believe I asked, it was Detective Holberman or Corporal Gabo, further testing could have been done. FTLE results. Item 7, the magazine, and item 8, the grip and the trigger, have the son's DNA. Now, I've been working with Mr. Turi a long time, I can kind of predict what he's gonna say. Keep in mind again, what I would say when he gets up here. But I presume he's going to claim, oh, it's just some sort of transfer. The fact that DNA, the biological profile of that little boy, is on the actual grip, trigger, and magazine of that gun. What happened in that house? Transfer in all those spots, Mr. Terry? All of them are just transfer? Well, with those statistics, no. I even asked Ms. Weinstein what the actual statistic was for little JJ's DNA on the grip trigger and the magazine, because she capped it at 700 billion, which understandable, it's greater than 700 billion. They don't bother reporting in their report, they put it in their notes, what the actual statistic is. So I asked her, what is the actual statistic for the trigger for the son's DNA? Way more than 700 billion, 640 quintillion. I had to ask her how many zeros that was. Can't remember if she said 20 or 30. You guys rely on your own memory. With those statistics, we ain't looking at transfer, folks. What happened that night in that house? The magazine, 310 trillion. Not with those statistics. Ms. Weinstein did tell you that they typically say, I expect the donor to be there. She flat out told you I would expect Mr. Bass's DNA to be on that gun. He would be an expected profile, and he was. It's his gun. So the state wants to focus you on that. Well, his DNA's on the gun. That means he committed this crime. Absolutely not. What did FDLE also say about the magazine? Mr. Terry, when he was questioning Ms. Weinstein, said, so Shirley's DNA is not even on the magazine, right? I objected. On cross, I asked, no, I can't include or exclude her. I'm not saying her DNA wasn't there. On the magazine, Shirley cannot be included as being a donor or excluded as being a source of the DNA on the magazine. And the FDLE analysts cannot tell you anyone did not touch that gun that evening. But what else is important that she told you? actually ways to do statistics, because we heard the statistics, 1 in 600 trillion, 1 in 700 billion, for it to be some other unrelated person. I said, wait a minute. We keep saying unrelated when we know this is a biological family. Are there statistics that can be done when it involves related persons? Oh, absolutely. Yeah, there can be a way to do the statistics when we have related people involved. But we didn't do it in this case. FDLE's not doing that. Everyone's related. Why didn't they do it? We don't know what the statistics may have been. On the magazine, we had little JAYLA included when running the program in StarMix. She uses StarMix, she puts the profile in, it helps her sort out the contributors. She ran it as a 2-person mixture. And JAYLA at that point was included, 25,000. That's a much lower statistic. But she told you, and I had to ask her this, wait a minute, couldn't you have chosen to run item 7, the profile in the magazine, as a 3-person mixture in StarMixed? And I showed her, we talked about her correspondence. She questioned whether she should have done that. She ran it, she chose to run it in the StarMix program as a 2-person mixture. That is her subjective doing. I'm running it as a 2-person mixture, and now in the end, we only have JJ and Mr. Bass. So we talked about her correspondence with her supervisor, and she said, yeah, we did discuss this, and I made the decision I'm going to keep it as a 2-person mixture. Ms. Michelin was our last witness. The gun that ejected the casings was that gun located in the master bedroom. And according to Ms. Michelin, to pull the trigger on that gun is like opening a soda cap with a little metal clip. Now, Miss Reader, in her closing, is like, well, you have to do this, and you have to do this, and you have to load the gun, and you have to rack the slide, and you have to do all this. There's no way a child could have done all that. I'm presuming that's what they're saying. All 3 safety mechanisms on that gun are joint. That's what you heard. So when you pull that trigger, the 3 safety mechanisms on that gun in different areas disengage. The only thing you have to do is you pull that little thing that's in front of the trigger, but right by each other, and you pull it. You don't have to keep racking the slide. You just pull it back, like popping a can of soda. And remember, we don't have to show you scenarios. We don't have to say, we believe this is what happened, or we believe this isn't what happened. You have to look to the state and say, did you prove that Mr. Bass pulled that trigger and did it with premeditation or felony murder? Because we could probably sit here all day and talk about scenarios. We're not going to do that. It is very strange what's in that kid's room. A baby little bassinet right in front of the bunk bed with, I guess she called it a clip to the magazine, is in that baby bassinet. What was going on in that room? No processing was done on it at all to see whose DNA, whose fingerprints might have left that right there. There's a purse in the kid's closet. I didn't make up the word purse. It is documented as a purse. A purse is in the kid's closet, a magazine, a holster, and .380 ammo. The same type of, I believe with the shots, there's like Hornaday and Norma. The same type of ammo. There's a full box in there that could have been used in that gun. The purse is not collected. Well, I find this little clip being important, so let's make sure, we take care of that, or we do this with gauze, but let's not collect the purse, test it for DNA, ask people about whose purse it is, test it for prints to determine whose purse that is, and how in the world did it get in those poor child's closet? We don't know. And it's tragic. We don't know. The witness, I can't remember who I was talking to about it. It must have been Bader or Hobelman. Yes, it was extremely odd to see this. So we have the sheriff's department documenting tons of stuff in the master bedroom, right? The gun, absolutely. The wallet, yes. But they're collecting all sorts of stuff out of that master bedroom, right? None of it had anything to do with this case. So that's important enough to do for them. I asked Corporal straight out, can you shoot 9mm? Because that's what most of it was, 9mm. And then there were some bigger ones in a 380. No, you cannot. Had absolutely nothing to do with this. But let's focus on that. Let's not focus on why in the world those items were in the children's room and why was the purse in the closet, where it's even a little tough to see when you look at the picture. And you have the pictures, and I had to ask, I believe it was Detective Hobelman about that. The only 380 items, which is what goes in this gun, were in that purse in the kids' room. That ammo box in the purse, the holster, the clip, did you swab it? Did you print it? Why is it in the kids' room? Who does it belong to? The see who touched those items. No, didn't do that. We were more concerned about all this non-related stuff in the master bedroom. Jennifer Michelon told you that they could have done a trigger pull to give you the exact trigger pull for that firearm. Because all firearms are specific and different, and you gotta look at that firearm. Just like Dr. Riley told you, everything with stippling depends on all these variables. We do not have any evidence of that firearm, that specific ammo being tested to see any stippling pattern. Nothing. We have no evidence to know. But she told you it, and she was honest with you in all her testimony. We could have done it. It wasn't done. She was the one that talked to you about how all the 3 safety mechanisms disengage. And then you have the little safety thing in front that's like right in front of the trigger. All you gotta do is pull the trigger. There's no testimony that you heard or any evidence you heard about whether that gun was loaded or not and whether there was one in the chamber. So if you're sitting here, like Ms. Reader says, you have to take it out. You gotta put the magazine in. You gotta rack the chamber, get it loaded. You heard no evidence of any of that. We don't know where that gun came from, how it got into the kids' room, who shot it, who is Mr. Bass protecting. We don't have any evidence. None. None. But we can't sit back there and assume, oh, well, children wouldn't have been able to do that because you got to do this and you got to do this. No. The lead detective in this case did not even know there was a box of 380 ammo in that kid's room. He found out during trial. Somebody told him, and that's fine. That's no problem. Somebody told him that. He didn't even know. He had no idea. He also testified, Corporal Gaveau, under oath in his search warrant, under oath in his depot, and made another mistake concerning the timing on the video. And he talked to you about that. And he admitted all that he had made a mistake, and his testimony under oath was not accurate. But Ms. Michelon told you it is like opening a can of soda. An adult can fire that firearm. A child can fire that firearm. And it's so funny, Ms. Reader made a big deal in her closing about how Jennifer Michelon used both hands to hold that gun. She's a firearms expert. She's a grown adult woman. She has to be safe too when she's at the sheriff's department. That's not what we're talking about here. Of course she's going to be safe and hold it with two. She didn't tell you, oh, I had to because of the way it was recoiling. Nope, none of that. Her testimony was what you heard, a can of soda. These aren't mere possibilities. This isn't speculation. This is their evidence. This is their evidence that they want you to remove the presumption of innocence with. And they have not. Do you know what happened that evening? A lot of details we don't know. Many details we don't know. So, when the state has not, through no fault of Ms. Reeder and Mr. Cherry, that is the evidence, have not proven this case beyond and to the exclusion of reasonable doubt. I know it's hard. This was tragic. But the law requires a not guilty verdict, and that's what not guilty means. The state just hasn't proven to me beyond and to the exclusion of a reasonable doubt. There's too many questions and too many things we clearly do not know. So when the state has not proven their case beyond and to the exclusion of a reasonable doubt, you mark not guilty. Remember, that's what not guilty means. You don't have to be sitting here going, oh no, I'm positive he didn't do it, and that's what not guilty means. No, the state has not proven their case. Not guilty, not guilty, not guilty. Charles almost over. Mr. Cherry's going to get an opportunity to come back and talk to you. Please give him the attention you've given me as well. Remember what he says and what I might say in rebuttal to that. You got to ask yourself, did they prove to you that you know what happened in that house, that tragic evening? And I was submitted to it. And on behalf of Ms. Bradley, and most importantly, Mr. Jermaine Bass, we want to thank you for being with us last Friday and all of this week. Thank you, Judge.
Thank you. Mr. Terry?
Yes, Your Honor. You know, it's interesting to sit there and listen to all that and realize she's got Schlemmer's doing her job. She's trying to find anything she can pick apart in the state's case, of course. She went through each witness and tried to find anything that they did wrong, any little tiny mistake. She spent a lot of time talking about Shirley Bass. And she ignored the strongest and the most important piece of evidence in this entire case. The words of her own client. The words of her own client, the first words that came out of his mouth when the deputies come in there to this horrific scene. She completely ignored that, ladies and gentlemen. She completely, and in fact, I guess because she's ignoring it so hard, she didn't even get right what he said. He never said he was cleaning the gun. He said he was removing the magazine. That's how much she's ignored it, is that she didn't even get the words he said right. Listen to the tape. Listen to what he says. I was trying to take out the magazine and it went off. I wrote down the quote exactly. I never said anything about cleaning a gun. But she's not listening to those words because she doesn't want you to listen to those words.
Objection, Your Honor, improper argument.
Sustained.
Those words are the strongest and most compelling piece of evidence in this entire case. She wants to tell you, well, that doesn't tell you who shot that gun. You know who tells you who shot that gun? He tells you who shot that gun. Jermaine Bass tells you who shot that gun. He said, I did it. And those deputies and those detectives began an investigation believing that man said it was an accident. So they want to look and see what's going on. And then it comes to light, this couldn't possibly be an accident with 5 shots. But he admitted it was him. And one of the last things Mr. Schlemmer said, something to the effect of, who is he protecting? Well, where's there any evidence he's protecting anybody? Oh, I can tell you who he's protecting. He's protecting himself. Those words that lie was protecting himself. He's caught. Hand in the cookie jar. Children shot. He's in the house. Murder weapons in his drawer. He's holding the baby. What does he say? It was an accident. That's the first lie he could come up with, right? You couldn't blame Shirley. We don't even know Shirley was outside. He said Shirley was in her room. Shirley wasn't in that room for sure. And why would he protect Shirley? Why would he protect Shirley Bass if she shot her children? He wouldn't do that. You know, earlier in the night, he was over there confronting her about whether she'd been drinking. Did you protect her? That common sense says to you, ladies and gentlemen, that it's not going to happen. No. He came up, he knew he was caught, he came up with the first lie he could think of. It was an accidental discharge. And they're like, wow, for both of them? Yeah. Yeah. I was taking out my magazine and it went off. But she wants you to ignore that. She barely even talked about it.
Objection, Your Honor. Improper argument and shifting the burden.
Improper argument sustained.
That is the strongest piece of evidence in this case. You can rely on that evidence and that evidence alone. That's an admission, ladies and gentlemen. He admitted to those deputies that he fired that weapon. Came up with a ridiculous excuse, but he admitted it. But he admitted it, leaving just enough truthful nuggets in it because he couldn't quite figure out the right way to lie. So that's what he says. Accidental discharge. Okay, that's the first thing he says. I was trying to take out the magazine and it went off, right? They was both in bed. He said that. They was both in bed. No one told him where they were or what was going on or where they'd been shot. That's actually true. They were both in bed. How did he know that? How did he know they were both in bed? Because he's the one who pulled the trigger. They was both in bed. Physical evidence shows they were both shot in that bed. I was in their room. Now he even puts the room where they were shot. Got the bed, the room. That's all true. So he's mixed in his lie with a little truth. I was in their room. They was both in bed. Where was Shirley? She was in her room. Again, those are his words, not my words, not words by the Corporal Gabeau, not words from Anna Cox, not words from Jennifer Michael, not words from any of those people. Those are the words of the defendant, the man right there. So every time Ms. Schlemmer says, well, that doesn't tell you who shot the gun. Well, I'll tell you who told you who shot the gun. He did. So Ms. Schlemmer said, he said, clean gun. That's not true. Another thing, and again, you need to rely on your own memory of the evidence. You need to rely on the evidence that you take back there with you. But she pulled that picture out to show the drawer open and the gun being. Watch the video camera of the body-worn camera with Daniel Jones when he goes in to clear that room. That drawer where that gun is found is almost completely closed. It may be open about this much. It is clear that they opened it more to put the markers on there. So yes, in fact, the defendant did take that gun after his two children were shot in the head, and rather than lend aid or render aid to them, he took that gun and he walked through that house while his children were bleeding out in their beds, took the time to do that, remove the magazine. Oh, again, a little nugget of truth thrown in there with that lie. I was taking out the magazine. Yeah, he did take out the magazine. Why, when your children have just been shot in the head, are you taking the time to walk down the hallway, go into your bedroom, pull out the magazine, place the gun down in there with the magazine, and close the drawer? Does that make any sense to you, ladies and gentlemen? So that was the way he did that lied, but producing enough nuggets of truth that his statements actually had some truth in it. And only the only person, the shooter, would know what those statements were. Where they were shot is huge. We only know that from Anna Cox because Anna Cox, who's the bloodstain expert who you heard from, was able to tell you that based on the bloodstain pattern, there was only one place these two children were shot, and that was in that bed, in that little corner up there. They were both shot in the head up in that northwest corner of the bed. And he knew that. They was in bed. He knew that scene. He knew where they were. I mean, that's as close to a confession as you're going to get, ladies and gentlemen. He's actually giving you details about the crime, the location, specific enough to where they were in the bed. The shooter would know that. The person who pulled the trigger would know that. That is the strongest and most compelling evidence in this case. And to ignore that, because the medical examiner wrote upward trajectory instead of downward trajectory, or the vice versa, would be an injustice. Don't lose sight of the forest through the trees. Don't ignore the strongest and most compelling evidence of this case, because the crime scene investigator wrote bottom bunk instead of top bunk. She made a mistake. So not only do his words follow along with the evidence perfectly, other than the accident, that's the part he didn't want to admit. He didn't want to admit his intent. It was an accident. I'm
Object,
sorry.
Your Honor, comment on silence.
Overruled.
So instead of saying his intent, which was to kill those kids, it came out as, oh, it's an accident. But on top of that, the physical evidence also corresponds with that. The location, just where he said they were. Where they were shot, just where he said they were. His DNA is on the gun. He knew where that gun was. They'd be like, where's the gun? Where's the gun? It's on the dresser. Well, it's in the dresser. He knew. How did he know? Because he put it in there. Who does that? A man with a guilty conscience. A man who's trying to hide away the murder weapon. That's who does that. This has been an accident. If someone else had done it, do you think he would take the time or bother to go and put the gun away? No, of course not. And it's no coincidence that gun was next to his wallet, because that's his gun. And you stuck it down in there. The shots were from off the bed. That's clear. If the shots to JAYLA were from a person on the bed, meaning JJ, there would have been skipping, ladies and gentlemen. There's no way that he would not have been shot within 12 inches. She would not have been shot within 12 inches. And there would have been some evidence of a close range fire if JJ had fired that gun. There would have been evidence of a close range fire. That gun was fired from off the bed, at least 2 feet away. Who could have done that? Not JJ. Oh, I know who could have done it, the man who admitted that he did it. Ms. Schlemmer says, you know, she knows me, she knows I'm gonna talk about transfer. Of course I'm gonna talk about transfer DNA. And yes, that is a very heavy statistic. So I have no doubt that JJ touched that gun, or that some fluids from JJ in some manner or another transferred from the hands of that man onto that trigger and grip. And remember, when she says trigger grip, she swabs the entire grip where you hold the gun as well as the trigger. So it could have come from the trigger, or the grip, I mean, it could have come from the trigger, or the trigger could come from anywhere. But yes, those transfer DNA. Now, possibly, and as we know, one of these shots goes awry. 5 shots were fired, 4 hit their target, 1 went awry. It went into the wall and into the bathroom. How could that maybe have happened? Maybe JJ, in an attempt to save his life, grabs the gun and pushes it away from his head, from them. And the gun goes up and shoots away from him. Maybe JJ did grab that gun. Maybe it was transfer DNA. But there's no evidence that JJ would have shot this gun. He's an 8-year-old boy. No evidence he had any animosity with his sister, any issues with his sister. Those shots were targeted. But also remember, he shot himself. Are we to suggest that he shot his sister 3 times, then shot into the wall, and then shot himself in the head? Oh, and hit his hand at the same time? He didn't shoot that gun. That's silly. It's silly to believe that he would shoot his sister and shoot himself. And that just makes no sense, ladies and gentlemen. No sense. So yes, this DNA was on there, but it's easily explained. You know whose DNA is not on there? The person Ms. Schlemmer talked about the most in the first half of her closing, Jermaine Bass. She is excluded from the grip and trigger. Excluded. She did not hold that gun that night. If she had held that gun and fired those shots, you better believe some of her DNA would be on that gun. She did not have that gun. There's zero physical evidence whatsoever that suggests Jermaine Bass did this. You know, and I know that you all may be sitting here wondering, we didn't get to hear from Shirley. I wonder what she said. Well, I'm going to tell you something right now. You did hear from Shirley. All of you did. You heard from her in that 911 call. And I urge you very hard to listen to that call. Listen to it, compare it with the video we have of her outside the Quan Evans apartment. Listen to how her voice changes, timeline and everything, because I'm going to suggest to you what happens. And you watch this and you will see that this is in fact what happens. And listen to the audio carefully and you will hear this. First of all, notice that when she is outside, the very first time she's outside, and you need to watch the video very closely. It is hard to see sometimes, but if you watch it enough times, you will know where the door is to the Bass household. You will see her come out, and she comes out at 21:15, which is 20 at 10:21. So she comes out a while before she ends up at the Quan Evans house. And watch her out there. You'll see her in the parking lot, and she's kind of walking like this, and then she'll walk, then she kind of walks another way, and then you'll see her walking this way before she ever comes to the area where Daquan Evans is. She's out of that house for a while. So what does she say when she's on that phone call? You hear her, she's frantic, she's terrified. She can't believe what's going on. She knows there were gunshots in her house. She says, someone shot my whole family. She's petrified. She doesn't know what's going on. She knows there were gunshots. And then she says, I don't know what happened in this house. She doesn't know. She didn't see it. She tells you right there, I don't know what happened in this house. She knows there were gunshots in her house. And she's scared for the safety of her family. But she says, I don't know what happened in this house, but she is scared. You can hear that in her voice. But she's not super confrontational, right? You can just hear she's like scared and she's not making a lot of sense when she talks. But then watch on the video. She has that phone for about 2 minutes and 20 seconds or so, 2 minutes, 40 seconds. And you'll see she starts walking back into the parking lot and she heads back to the house. And look at the house, you'll see the door open. And that's when she first screams in really loud, clearly not at the 911 operator, as they would have you believe. She's clearly speaking to someone out there. And she says, "What the fuck is wrong with you? What the fuck is wrong with you?" You know who she's talking to? She's talking to that man right there. What the fuck is wrong with you? Because she knows he did something. She knows he had that gun and she knows he did something. But she doesn't seem to really know what yet at this point, because you don't see her say anything, and then she calls him, "You fucking asshole." And apologize for my language, but I'm trying to quote to you exactly what was said on that day, on that phone call, which I urge you to listen to. But it's at the 2 minute and 40-second mark. Her voice, her inflection, everything changes, because at that moment, she has now seen Jermaine Bass and she's seen him holding her boy. She says, "That man was playing with his freaking gun. I don't know what the fuck happened." Again, I don't know what the fuck happened. She doesn't know. All she knows is that her husband, of all people, had a gun, and then suddenly gunshots are going off, and he walks out with his son in his arms. And that's when there's a realization, because you'll hear that now suddenly she starts to give some more specific. "My babies, my kid been shot." She doesn't say my kids, she said my kid. Singular. At this point in time, she probably doesn't even know JAYLA shot up there. But now she's seen JJ. "Bring the ambulance. My son is bleeding. My son." Again, she doesn't say JAYLA. Why? Because at this point in time, she was outside and she sees her husband come out and he's got the boy. She doesn't even know what's going on with the girl. She doesn't realize that her daughter is dying upstairs. This is Shirley's testimony, ladies and gentlemen. Unfiltered, raw, emotional, at the time, the most trustworthy statement you could possibly get from an individual when they're in the experience at the moment going through it. And what is she telling you, ladies and gentlemen? She doesn't know what's going on, but she knows something bad is happening in her house, which means she's not there, she has nothing to do with it, she's not involved with it. The phone disconnects. You hear her come back in. If you listen, you can tell there's an echo. She's inside that house at that point. She yells at him, "Leave him alone, don't touch him." She says, "I swear to God, if my son died," and you can hear all this on that phone call. And yes, she's very rude to the 911 operator, but remember, she's now realizing that her son is shot in the head. She doesn't know what's going on. She doesn't understand it, but she knows that that man right there, Jermaine Bass, has something to do with it. That man playing with his freaking gun. Ms. Schlemmer wants to talk about how uncooperative Ms. Bass was. What did the detective tell you? On the day this happened, while her daughter is lying there dead, and her son is in a coma in the hospital, she spends an hour talking to him about this. Think about this, ladies and gentlemen. This woman, whole world has just exploded. Everything has exploded. The husband, the man she's in love with, is now being investigated or believed to have shot and killed her daughter, and her son, who could potentially die, is there in the hospital. Her mind is reeling. And Ms. Schlemmer wants to sit here and talk about her cooperation. She spent an hour, Detective or Corporal Gallo told you, she spent an hour talking to me. And he went back the next day and talked to her for even longer. And Ms. Schlemmer wants to call her uncooperative? You know what uncooperative is lying to police. Who do we know did that? Mr. Bass. She wants to get up here and tell you, well, he was cooperative that whole time. No, he wasn't. How is lying to police cooperative? They based you heard Corporal Gabriel, we based our investigation on what he said happened. They weren't looking for a whodunit or who's the other person that might have done this. He told them I did it. But it was an accident. So that's how they're basing their investigation. So again, remember we talked to you earlier, we don't have to prove motive, okay? And I think you all understood that, and we went through that in some great detail. But I told you, you're gonna get some evidence that something was not right, and I think you heard it. You heard it from China Gadsden, who got up here. And she told you that she was being aggressively tailgated as she left Ruth's Chris. And that's why we presented all that evidence to you, to show you and to corroborate what China said to you. Because we know that that man left those kids alone, got in his Nissan Titan truck. We see him pulling out from the residence. We see him driving down Fletcher towards the interstate. We have his phone records that show his phone going all the way down to West Shore, where he's there for a couple of hours. Not sure what he's doing there, but he's there, waiting until Shirley leaves, at which point he aggressively tailgates her. China's, what is this guy doing? She doesn't know it's him. The only evidence of anyone being aggressive, acting abnormal that night, is that man seated right over there. Not Shirley. How was Shirley? Shirley was fine. She was just normal. She was happy. It was her sister's birthday. We were all out at dinner. The only person with any sort of aggression that night was that man seated right over there. And we proved to you, ladies and gentlemen, that. And we don't have to prove to you motive, but something was not right. He was clearly upset with Shirley for some reason. You don't follow your spouse to a dinner, wait outside, and then aggressively tailgate your spouse is leaving the dinner, and then get up in front and stop him from driving anywhere, and then we'll go up and accuse him of drinking. You don't do that unless there's something very, very wrong. Jermaine Bass took that anger home and unleashed it on his children. Whether to punish Shirley Bass or for whatever reason, we don't know, but he took that anger out and he put it into his children. Again, zero physical evidence to suggest Shirley Bass had anything to do with this. In fact, everything seems to indicate the opposite. You see her behavior, you see her franticness after this happens. You hear that 911 call. And I'm telling you right now, listen to that 911 call. That is raw, that is pure, that is when a person is experiencing the moment. And you can tell she doesn't know what's going on. She is frantic and scared. But the few moments that she says anything that you can tell that she knows something happened, is she is accusing that man right there. What the fuck is wrong with you? You know, Shirley was the one trying to attempt to get help for her kids. We know Mr. Bass had his phone with him because he made a phone call. While Shirley's out there going, get that ambulance here, send an ambulance. Is Mr. Bass calling 911? And Ms. Schlemmer says, well, Shirley was doing that. How does he know what Shirley's doing? She was out there. She was outside. She was outside trying to find a man to help her. Someone who could give her a phone so she could call 911. Most likely because she was too terrified to go back in the house, not knowing what's in there. So she finds a man who's willing to, who helps her, gives her a phone and calls 911. And what is he doing with his phone? He's calling his mom. He's not calling for help for his children who've just been shot. Is that what a father does?
Objection, Your Honor, improper argument.
Sustained.
This was an accident. I think the first thing you want to do is call and get some help. Certainly not put your gun away neatly and close the drawer and call mom. There were 4 people in that household. JAYLA's gone. JJ, Shirley, and Jermaine are here. And I've shown you, I believe, and proved to you that Shirley could not have done this. She is excluded from the DNA on that gun. She never touched that gun. At least not the grip or the trigger. Physical evidence does not connect Shirley in any way to this case. Her behavior afterwards is typical of a person who's just gone through a serious traumatic event. What's not typical was the behavior of the father, of Jermaine. So the only other question is, Jermaine or JJ? Well, remember, don't ever forget this, the father is the one who admitted he shot that gun. And that's why Ms. Reeder spent so much time with that crime scene investigator to talk about the angles and everything like that. To show you, ladies and gentlemen, that that shooting came from off the bed. And we know JJ was shot on the bed. And then also ask yourself this, 2 people, right? Those 2, JJ shot himself in the head? That doesn't make sense. But again, no evidence of close range firing. The angle from which those shooting shows that the shooting came from off the bed. This was not JJ. JJ had nothing to do with these shots. JJ was innocently laying there with his sister. And that man walked in and brutally shot them both. That's what happened. It's so simple. It's right there in front of you, ladies and gentlemen. And you can pick apart a medical examiner's report of up or down.
I'm gonna object, Your Honor, improper argument, denigrating the defense.
Sustained.
We can look at little things like that, but what we need, don't forget and don't miss the biggest stuff in this case. The strongest, most compelling, biggest piece of evidence. And that is the statements from Jermaine Bass on that night and the statements from Shirley Bass on that night. Look at that physical evidence, and you will know that these shots came from off that bed. That excludes JJ. No DNA of Shirley, that excludes Shirley. That leaves that man right there, and guess what? That man admitted he did it. Very simple. This is not a complex case. There is no doubt whatsoever that on that night, on August 29th, 2022, Jermaine Bass, he told you he did, told those deputies that he did, that Jermaine Bass shot and killed his own daughter, JAYLA Bass, and tried to shoot and kill his son. That, ladies and gentlemen, is murder in the first degree, premeditated, because look at the placement of those shots. This reader showed you that. There is a picture of JAYLA Bass, and you can see those 3 shots, well placed, all within a very close range. Does anyone think an 8-year-old boy could do that? Really? Sure, an 8-year-old boy can fire a gun, but with that kind of precision and accuracy? That takes someone who knows how to fire a gun. You know, we did introduce a lot of evidence of a lot of other bullets. That's to show that Mr. Bass knows guns. Yes, there's clips, holsters, there's all sorts of stuff. There's that one thing where it has all the bullets in it. We presented that evidence to you, ladies and gentlemen, and proved to you and show you this was not an accident. This man knows guns and knows how to fire guns. He knows how to aim that gun. And he put those 3 bullets into the head of his daughter. And he put that 1 bullet into his son, who still has to deal with that 1 bullet. That's first-degree murder. That's attempted first-degree murder. And that is aggravated child abuse. Both counts. It's not only premeditated murder, it's felony murder, because he is guilty of aggravated child abuse for what he did to those children, and that makes it felony murder. And I'm convinced, ladies and gentlemen, that when you go back there, use your common sense. Think about what is the evidence to best rely on. The state has no doubt that you will return a verdict for guilty as charged on all 4 counts. Thank you for your time.
Thank you. All right, so it is almost 6 o'clock. My intention, unless you would like to vote to overrule me, is to go ahead and release you for the night, to come back tomorrow and begin your deliberations fresh tomorrow. If you would like to overrule me, I see a bunch of you nodding already, and would like to start deliberations tonight, I will certainly stay here and allow you to do that. But I see by the number of you packing away your materials that no one wants that option. Is that correct? Correct. All right. So a couple of additional admonitions, other than the usual, no discussion about the case, no watching the news or local media or any reading anything related to the news. But most importantly is my admonition about not coming to any definite, fixed, or final opinions on what you've heard. So a natural reaction is, oh, I've heard everything. I've heard the evidence. I've heard the final arguments to the lawyers. I've heard most of the law. There's a little bit left to read. But the reality is you have not engaged in the most important part of your deliberation process, and that's discussing the evidence with everyone else. So sometimes when I discharge people at the end of the day, they go home and come to such a resolute idea about how they're going to vote that it makes it hard for them to interchange information with everyone the next day. So I'm going to ask you to please try to do everything but that. Come to some final fixed opinions on what you've heard, that you're not able to intelligently discuss it with everyone tomorrow. Does everyone understand where I'm coming from? So just, keep your final thoughts to yourself. Allow for a thorough and usual debate on the evidence and deliberation tomorrow. So don't come to any such fixed opinions that you prevent yourself from doing that tomorrow, in other words. Any logistical questions before I let you go about any of those admonitions? All right. So same time, meet the bailiffs, 8:45. So I'll get you back in here. We'll finish up to some very brief instructions that I have left to give you, and then you'll retire to begin your deliberations. So have a great night and a safe way home, and thank you for your patience. I know it's been a long day for you with a lot of information. So thank you very much for that.
All right.
While we're all still here and on the record, talk to
Mr. Romeo.
Mr. Romeo in our front row. Will you come forward for just a minute for me? Come on up.
Yeah,
Yeah.
sorry, come step up.
Yeah, right there is fine. If you would tell me your full name.
Richard Romeo.
Okay, and you are related in some fashion to Shirley Bass, the mother of the victim children in this case. Is that correct?
That's my daughter.
How is that relation?
Very good.
No. I meant how are you related specifically? Are you her father,
Yeah, I'm a
father-in-law?
dad. Yeah, no, I'm a dad. I thought I said yes.
You're her dad.
Yes.
Okay. So I just want to make sure because you're not a witness in this case, obviously,
No.
but the rule of sequestration has been invoked, which means the witnesses cannot talk to each other about the testimony that happens here in the courtroom. By virtue of your occupation with a local news channel, you've been recording the proceedings and participating in the news reporting in some form or fashion with your company. My inquiry to you is, have you used any of that material that you all have recorded, or have you engaged in any discussions with any witnesses or the parties in this case about what's happening in the courtroom?
No, Your Honor, I have not.
Okay. Does anyone have any questions?
Just any contact with jurors?
Oh, any contact with the jurors at all?
No, I don't know.
Uh,
No.
I know, but you haven't come
No.
in contact with them or
No, Your
obviously showed them anything about the case or
No.
any discussions with them?
No.
I have no other questions.
All right, I just wanted to put that on the record because it's kind of unusual that halfway through the proceedings, we became known of, you obviously knew that, but we had no way to know that. So I just want to make sure that the record's clear that nothing inappropriate has happened by virtue of your relationship and your job.
Okay.
Okay,
All right. Thank you.
thank you very much. I appreciate that.
You read Jermaine Bass sometimes when it was printed in the jury instructions, Jermaine Lavanda Bass. So just want to make the record clear that the instructions themselves distinguish that anytime it's referring to my client, it's Jermaine Lavanda Bass, and anytime it's referring to his son, it does say Jermaine Bass. And I know
All right,
because
and
there
now,
were 22 pages, sometimes you read it
right,
the other way, but it's clear in the instructions who it's referring to.
sure. And if you want me to point that out before I finalize the instructions to the jurors tomorrow, I will, because I am going to point out that to them that the three changes I've made to the final instruction. One is on page 2 of 22, in intro to homicide, in deciding if the killing was first degree murder or any lesser included, it should be offense instead of defense. So I changed that in these and highlighted it.
You read it correct. You read it as all.
I know,
You fixed
but
it as you read it, yes.
and on page 4 of 22 that we already pointed out in the record, while engaged in the commission of an aggravated child abuse on either JAYLA Bass or Jermaine Bass in counts 2 and 3, or any lesser charge on those counts, I crossed out or any lesser charge on those counts and just struck through that language because it does not apply to the lesser counts. And then on the verdict form, as I read to them, I didn't put a yes or no on one of the interrogatories. On page 22, under A, did the discharge cause great bodily harm to the victim? I didn't write yes or no, and I have on the official verdict form. So I'm just going to highlight to them those changes that I make. So I'll be happy to point out the difference in the Jermaine Lavanda Bass and Jermaine Bass if you want me to do that tomorrow as well, and tell them to rely on the written instructions.
Yeah, so I think that would just be safest. I know in the verdict form itself, it refers to the son as JJ.
Yeah,
And I know there's been a lot of talk about Jermaine Bass Jr. or
Sure.
the son or the father. So just to let them know, I think it's pretty clear, but just to remind them.
sure. Just remind me in the morning to do that, and I will.
Okay.
All right, anything else? All right, then I'll see you at 8:45.
Court's adjourned. Thanks for stopping in. We hope you will join us again. We all look forward to next time. We get to talk about true crime. Clues. Justice served in an honest fight. True crime tales till the verdict's right. Solving more than just trivial quests, where sentences rule and the defense rests. Our true crime family is great. All types of topics we debate. Smash that like and ring that bell. Hit subscribe, you might as well.